For reasons mentioned in the judgment, the appeal is allowed. We are giving benefit of doubt to the appellant and acquitting him of charges under of section 376(2)(1) of the IPC as well as section 4 of the POCSO Act 2012. The appellant be set at liberty if he is not required in connection with any other case.
Apply.
Item 1.
It is your Lordship. It is the appeal filed by NIA, Lord. And on the last occasion, Lordship was pleased to direct the registry to prepare the paper book. It is not yet ready. If Lordship is pleased to look at the order dated
Yes, yes,
17th of February.
The paper book you want?
Some record may from the trial court may be required. Additional.
Okay, some records are to be called from the Chabo for
Yep.
so far as Chabo PS case is
Lord.
concerned. Okay, we'll grant some more time.
Lord.
And we'll direct for listing for orders so as to fix for hearing
Lord.
immediately after preparation of the
Lord.
paper book.
Lord.
Okay? Heard. 3D Cycle and Senate Council. Assisted by, what is the name?
Satyanarayan,
Assisted by Sri Satyanaran,
PP and
AP
I.
and I for the appellant. Also heard, also heard Sri Botakur, as Botakur, Learned Council for all the respondents. Para. Peruse the order dated 17/2/2025. Passed by us directing preparation of the paper book, wherein certain materials were specifically laid down to be incorporated. Para. Office note dated 27/3/2025 has, however, indicated that certain documents for preparation of the paper book is in the disposal, is in the custody of the learned CJM Dibrugarh, which have been called for wide communication dated. No, which have been called for. Para. In view of the above, comma, the matter is adjourned by further 4 weeks to enable preparation of the paper book after obtaining of the documents, and thereafter list the same for orders so as to fix the date of hearing.
Highly applied.
Deeply applied.
It is into office to transmit করা হচ্ছে 21 থেকে পড়া order কেউ বাহানে হবে বুঝি পান আপনাদের অফিস না দর্শন হয় রিসেন্ট অর্ডার না হয় এটা দর্শন office to issue reminder for procuring the aforesaid documents as the last communication appears to be of the year 2021.
The K Borua is not there.
Who is K. Barua?
Unable to make out. M.
Kumar.
Alam and
Is it
Peter.
Kumud Barua?
Might.
Kumud Barua. No, not Kumud Barua. 2007 member.
Otherwise, it's for admission, Lordship
No,
can
that is
admit,
it.
but in
We
their
could have
absence-
done, we can do the admission, but we want to record their presence.
Hmm.
We wait for a while, otherwise
No,
we'll
sure.
have it for another day.
Yes,
Okay?
there is no IO.
But Hukurbar Lalani. We can have it on Friday then, madam.
Better.
In view of the absence of the learned counsel for the appellant, the appeal is adjourned to be listed on Friday. Fair? Ms. Jahan Learned APP is present.
Item 2.
May it please your lordship.
Yes.
Lordship, this is a criminal appeal against conviction under section 415 subsection 2 of PNFS against the judgment and order dated 5/3/2025 and POCSO case number 55 of 2019, wherein the appellant has been sentenced to undergo rigorous imprisonment of 20 years under section 376 subsection 2 of the IPC.
Conviction is under both, but sentencing is under 376. So
376, the victim is not required.
not required. 2, it is not required.
Oh.
A, B, B, A and all those very.
Okay.
But
This is
he
a
has made-
regular appeal. Has he made party?
he has made her a party.
Okay, we issue notice.
Not.
Your wife Kuthari,
Why Kothari?
you are not on record.
I believe it has not reflected in the.
Have you signed the Wakalata?
Yes, I have signed it, lordship.
Third, Sri Y. Kothari, Learned Counsel for the appellant who has preferred this appeal under so and so. Admit. Call for the records. Ms. Jahan, for state respondent. Let steps be taken for service of notice upon the respondent number 2 in the manner prescribed. This is not required to be routed through you, or is it?
Not required.
Uh,
Let it go by normal.
in the manner prescribed, steps within 2 working days. List after 6 weeks for report on receipt of records as well as service upon the respondent number 2.
Lordship, I is also that may be taken up.
We are issuing notice.
Lord,
Heard Sri so and so, Learned Counsel, for the applicant who has filed this application under so and so. The connected appeal has been admitted today. Para, let notice be issued. बाकी सब एक ही है. सिर्फ records वाला नहीं चाहिए. List after 6 weeks for service report. इसमें record नहीं चाहिए.
TPF.
Yes. I see what it is. Yes.
Different post. I
You
did
should have somebody, madam.
Lord, I'm so sorry.
No, you should have somebody. There are 3 counsel. We don't mind adjourning a case, but we don't really mind. Nobody
I
is
deeply
appearing.
apologize, Lordship.
Somebody should be there.
It's not.
Okay.
Lordship.
What is your name? Does.
P. Bora, Lordship.
You're not on record.
No, Lordship.
On behalf
On behalf of Mr. K. Bora.
P. Bora.
P. Bora, Lordship.
BORAH
Yes, Lordship. You are.
on behalf of K. Borua. What is the conviction under?
Lordship, the appearance was convicted under Section 6 of POCSO Act.
6
He was sentenced for an imprisonment of
Okay.
25 years.
POCSO. So POCSO वाला होगा. हाँ? Same order. Admit. Call for the records. Jahan for respondent 1 and 2. To be routed through the office of the PP. Huh? 6 weeks for service report as well as बाकी सब. You take steps through the office of the PP.
Lordship. Deeply apologize.
Ensure that somebody is there.
Item 3.
As Chakraborty. You're not there.
Mrs. S. Chakraborty.
Not. This is under, I think, 30.
What is happening? Nobody is appearing. All of Rokhani. All of Rokhani not already. Let's wait for a while. Otherwise, we'll have it on Friday. पहला वाला order इसमें भी रहेगा अगर नहीं आया तो.
4.
May it please your lord.
Yes, Mr.
It is a
Bhattacharya.
conviction under section 376(3) and 4(2) of POCSO Act, but he has been sentenced under 376(3).
You have made the victim a
Victim of
party.
Yes, my
Yes.
lord.
Okay. The same order as in item number 2. D.K. Bhattacharya, huh? You have an IA also?
I am.
Okay, same order. We're issuing notice in the IA?
True.
Yeah, and you take steps through the office of the PP.
My lord. Apply.
Otherwise, sentencing is only under
Yes.
376.
It's free. Sentencing is only under
Okay.
376.
Normal.
Steps is not through the PP, exact item number 2, huh?
Normal.
Normal steps as per the manner prescribed within 2 working days.
Apply.
Okay.
Item 5.
Lordship, on the last occasion, the Union of India was supposed to file affidavit. Yes, there's some more that I got to file affidavit.
Why? This is this matter has to be resolved.
Yes.
He has, the period of his sentence is over.
Yes.
You cannot detain him now.
Now they have communicated to Myanmar.
Now,
that
how
they have-
long will it go on? He was sentenced, he has served his sentence, now you deport him. Now, how do you detain him then? Under what provision of law?
So we have communicated to our status report is there, madam, but Nana report directed to file affidavit, madam, in this regard.
Till how long will you keep on communicating? What will be the period, the consequence of this period after the sentence was over?
Madam, affidavit, madam, to file the affidavit, 3 weeks time required, but only last of
When was he released from, when was the sentence over? Madam, when was the sentence over?
23rd of December, your lordship, 2020,
2020?
2020.
2020? See?
So it's more than
So what
50
will happen to
months.
this period? Can you give him this period? This is illegal detention. Under what provision of law you are detaining him? Tell us.
Your lordship, his sentence was supposed to end on 12th of March 2020.
Madam Gayan, this cannot go on like this. Have you seen the order sheet?
yes, madam, I have come.
Very sorry state of affairs. Every time you are seeking adjournment. If you do not file, we'll have the officers in the court. Let them
My
explain.
status is there, madam, but because
No,
filing
how are you planning to resolve the issue?
for that
Is it a
file
matter
affidavit-
where one should come to the court that I have completed my sentence, yet I am behind the bars? You don't trust these decisions upon the court. This is a decision you have to take. How do you deport? What to do? This is your decision, your domain. We are not going to interfere, but we will not allow the person to be put behind the custody after a period the sentence is over.
this is the communication with the peer.
Now, what have you resolved? What is the resolution? How do you resolve the issue? Tell us.
Here by the Bureau of Investigation, that is 5/7/2023 letter, madam. I'm directed.
5/7/2023. We are in 2025.
Yes, madam.
You are relying upon an instruction of 2 years back.
And that is the, madam, our,
I think your officials should be here in the court.
madam, 14/1/2025, we have received that is the office memorandum was there, madam, 14/1/2025.
What has it said? How are you resolving the issue?
Madam, in paragraph 4, that is also in the top there also, madam.
Yes, paragraph 4.
Copy is there, paragraph
Yes.
4. This further submitted that the necessary verification and essential prerequisite for the person
Madam,
of the
this-
illegal
this-
migrant.
This was given to us before the last order.
Yes, madam.
We had taken up this matter on 28/3/2025. This is not something new.
Last answer be given to the positive will file within 6 weeks, madam.
We
Thank
fix a date. If you do not file, we'll have the officers in the court.
Within 3 weeks.
Not 3 weeks. We had given you enough time. What is your name, madam?
Yes, the your lordship.
Yes, no. Heard Miss S. Never Learned Counsel for the petitioner. Also heard Miss A. Gayan Learned CGC. Para. This writ petition was filed in the year 2023, in which notice was issued on 26/5/2023. It pertains, the prayer made in the writ petition is as follows. Quote the prayer. Full stop. Thereafter, the matter was listed on countless occasions, and yet the matter has not been able to be resolved by the respondents. Para. When the matter was taken up on the last date, that is 28/3/2025, this court, after scrutinizing the affidavit filed on behalf of the state, had noted that the matter was taken up with the Ministry of External Affairs, Government of India, and steps were being taken for deportation of the petitioner to the concerned country, namely Myanmar. Full stop. However, and accordingly, the central government was directed to file an affidavit to put on record the status of the process. Full stop. Para. Oh, no, not para. Such affidavit was directed to be filed within a period of 3 weeks. Full stop. Today, when the matter has been called upon, the learned CGC has renewed the prayer for grant of further time to file affidavit. Full stop. Para. Though this court is agreeable to grant further time, this would be the last opportunity to file the affidavit, as the writ petition is pending since 2023. Full stop. Para. Accordingly, we direct listing of this case on okay, 3 weeks, 14th of May, by which date, the affidavit is invariably required to be filed by the Union of India. Full stop. We make it clear that on the failure to file such affidavit, we may be constrained to have the concerned officers present in the court to explain the matter.
Master, pleasure.
In 6.
Item? Anshuman Dhar has been appointed by, I don't think he's, huh? No, no. Adhar. Arunangshu. While this appeal was admitted by the order dated 19/7/2024, this court, noticing that the appeal was preferred from jail, had directed the registry to appoint an amicus to represent the appellant. Full stop. The records indicate that the registry had appointed Sri Arunangshu Dhar by notice dated 12/2/2025, whose name, however, is not reflected in the court list. Para. Let this matter be accordingly adjourned to be listed after a week by reflecting the name of Sri Adhar as learned amicus for the appellant. Please inform Mr. Dhar also.
Item 7.
May it please your lordship. This is an application for suspension of sentence. The ground sought is the person was mentally ill at the time of occurrence. The lordship takes up the IA.
Yes. You have filed objection, madam?
The objection.
The merit of the
The lordship
No,
takes
no,
up
on the
the
IA. Okay.
IA page 24.
Yeah. IPC. IPC. Eighty-four you are invoking.
Not 84, my lord.
Then,
My lord, what I want to argue is the PWs, most of them have said in their cross-examinations that this person was suffering from mental illness. In their cross-examinations, they have stated. Even the impugned judgment states that. Now, if as per 328 of CRPC, and if the court comes to an opinion that there's something may be wrong with the person, court may suo motu go for an inquiry. That was not done. Even barring that, my lord, even barring that, suppose I have not taken all this ground. He is a prisoner with mental illness.
no, that procedure, failure of that procedure, will it be a good enough cause to suspend the sentence?
Not
If you
suspended
are
of
not
sentence.
invoking, if you are not invoking 84 or bringing in the application of 84 in assailing the judgment
Right.
for the purpose of pressing this application, can we go to the procedural aspect and say that no, since that procedure was not followed, so we suspend the sentence?
That's what, my lord. Suspend may not be suspended as of now, but he cannot be kept in jail because this act, the Mental Health Care Act, this specifically says that. I'm invoking this.
Have you given a status report regarding his medical health?
That is not there.
See, Mr. Bhattacharya, there are two aspects. Firstly, we had contended that at the time of occurrence,
Right.
which is the most crucial factor so far as the merits of the conviction and sentencing is concerned,
My lord.
we'll definitely look into it, what are the materials available. So far, the point when the occurrence had taken place. Now, the second, which we have understood, is giving him the proper medical treatment as of now.
My lord.
This is
My-
another aspect.
Yes.
This is
My- true.
you are probably on the second aspect.
Second aspect. I'm on the
Second aspect. For the second aspect, we'll have a status on his medical health. Which jail?
Which jail?
Mori County.
Murigaon is not very far.
I'll get a report. Detail
What
operation.
kind of mental ailment you are having?
He's, as per our information, he's a schizophrenic person.
Where is the medical document?
My lord, that is our information. We have
No. In your IA,
no, we have not given a medical document. That's why we have asked for a.
Any plea you have taken in IA? Is
We have just only
schizophrenia?
stated the
No,
statements of the IA.
schizophrenia is not something we'll perceive.
My lord.
It is a disease. It is an ailment which has to be certified.
My lord.
At least come out from the doctor's paper.
My lord, issue
You
is
don't
that-
have any document.
No, my lord, actually this person was in jail. Nobody was preferring his appeal. When we went to a jail visit, we found out that this was
Technical
there.
aspects we cannot ignore it. It may
When
be.
we went to jail, we found this, so we took this up. A similar matter has happened in Morigaon jail only. If report is called for, under this act, there has to be a medical review board. And there are 5 districts under which Kamrup Metro exercises jurisdiction. So Morigaon falls under that. So if a report
Okay,
is called
madam,
for,
you have
I'll get a
first you
report
get a status.
District jail, Morigaon.
district jail mode.
See, even that in that aspect, Mr. Bhattacharya, there will be two features which you have to see. One is the languishing in jail. That's a different matter, and the other is what you're trying to press is his present health condition, mental health condition. Languishing part, the appeal is before us. We'll expedite in hearing the appeal. The conviction sentence is of which year?
Sentence of 2017.
2017.
And he was under trial.
Under-
All along.
All-
A trial started when?
Trial was from 2015.
Okay, almost 10 years. What is the sentence?
It's life.
302.
30.
Okay. My appeal has been admitted, we believe. Paper book prepared.
Paper book.
No
is not-
paper.
Paper book is-
Okay. We'll also direct expeditious preparation of the paper
My-
book. If this takes time, we'll try to.
Lordship, Elser is not available. As part of the court. And I quoted the court. Not written in the court, not reflected.
LCR
comes.
Detective को भेज दिया ने ऑफिस में ओके क्रिमिनल अपील assessment. The IA has come for the first time.
My lord.
We file our
No, they file
objection.
objection.
Okay.
No, second phase.
Okay. You write in the IA, huh? Heard Sri D.K. Bhattacharya, learned counsel for the applicant. Full stop. In this application, notice was issued on 18/11/2024. And in the meantime, the state has filed written objection, which is on record. Full stop. The objection is mainly on the merits of releasing the applicant. Merits regarding the prayer of the applicant for suspension of sentence. Full stop. However, Sri Bhattacharya, the learned counsel, has submitted that presently also the mental health of the petitioner is a matter of concern for which proper treatment is necessary. Full stop. On that aspect, we direct the learned APP to obtain necessary instructions through her through Ms. Ardas, through the office, through her good office. क्या बोला की बोलो रास्ता to obtain instructions office regarding the health condition of the applicant from the concerned Morigao district jail. Full stop. There is a jail doctor.
There's a deal.
Yes.
The instructions is to be accompanied by a certificate from the concerned doctor of the jail. Full stop. In the meantime, we also direct. In the meantime, noticing that the records LCR, TCR,
TCR.
TCRS have been received. We direct preparation of the paper book.
One small present mental health, not health.
Mental health condition.
Apply.
If he is physically unwell, health will include everything.
My lord,
Where are you confining it
we
to mental
have
health?
we have faced these things, my lord. Have
Why only
happened.
mental health?
Physical health, he may not be getting this benefit of mental health care. He won't be
Physical
getting.
health also, you may need some better treatment outside.
Your Lordship, please give a date.
Date.
Tell us, list after 3 weeks. We give a date.
Okay.
List on, don't say 3 weeks, list on 14 May.
Okay.
Let a copy of this order be furnished to Ms. Ardas, assisting Ms. B. Bhuya, the learned APP.
Okay.
May I please have
Yes, Madam Bodler.
I have paid as legal aid counsel for the appellant. 504 days, it was a 504 days delay, my lord.
Okay, notice was issued.
Yes, my lord.
Conviction under what?
Section 8 of the POCSO Act, my lord.
POCSO Act.
6 Act.
Notice served on the private respondent.
Yes, my lord.
There is a new office address. I think you should try on the new address of the respondent number 2. Earlier address, she is not being able to be served. An attempt was made to serve her by WhatsApp Messenger with another address. Okay.
Her address is otherwise shown as Panchabari, Guwahati. We'll send it to the correct later. address.
Yes. বৰ্তমান স্থানীয় ঠিকনা মনিকা বৰুৱা wife of শংকু দত্ত উজান নগৰ বৰখোলা কাছাৰ
Oh, now she is married and she has left.
yes you verify with the records of the court records you can take this address okay we can indicate in the order also.
No.
Third, are you seriously objecting to the aspect of delay?
Not
But
object.
we'll ensure that the notice is served upon respondent number
Yes.
2.
After that,
Then delay condemnation in a criminal case may not be a matter of grave dispute or tussle. But we have to ensure that notice is served. Third, Ms. P.B. Bodler, Learned Legal Aid Counsel for the applicant. Full stop. Notice was issued in this application for delay condemnation on 29/1/2025. Full stop. Also heard Ms. Jahan Learned APP on behalf of the state respondent. Para. So far as the respondent number 2 is concerned, as per office note dated, no, not office note, as per order dated 10/4/2025, passed by the Learned Law Jima Court, comma, while an attempt was made to serve the notice upon the respondent number 2 via WhatsApp Messenger, comma, there is also a report of change in address of the said respondent number 2, which is as follows. Follow. এইটো দি দিবা হা এইখন ফটো তলৰ খিনি এই কিবা মনিকা বৰুৱা শংকু দত্ত we accordingly direct the Learned APP to take steps for serving of notice upon the respondent number 2 in the aforesaid new address. Full stop. List after 4 weeks, along with a report from the concerned PS regarding serving of notice.
that's her piece.
Para, let a copy of this order be served upon Ms. Jahan for doing the needful. You'll get the address in the order. Madam, after 4 weeks.
I did 9.
This petition has been preferred under section 5.
Delay.
Yes, madam. 23 days.
Conviction under
Section 4, madam.
POXO.
Yes.
Okay. Notice you'll have to go. Your H. Chaudhary.
Yes, Islam.
Your S. Islam.
Sir,
Or-
my name is not mentioned in the first list. Someone, I have the filing at, my name is maybe,
Your name is there.
but in the
Saidul
first list,
Saidul Islam
yes, madam.
is there in the cause list.
It's there. It's in the IA, or it's in the A, criminal, not the I.
Yes.
Criminal appeal is more important.
Yes.
Third, 3S Islam. Who is Mr. H. Chaudhary then?
Senior public file.
Arshad Chaudhary.
No, madam. After the
Oh, his name is not there in the cause list.
first one.
Khusru's name is not there in the cause list.
His name may be.
Okay. Third, 3S Islam Learned Counsel for the applicant who has filed this application under Section 5 of the Limitation Act, praying for condonation of delay of 23 days in preferring the connected criminal appeal. Para. The appeal has been preferred against a judgment and order passed by SNC. Para. Issue notice returnable by 6 weeks. Ms. Jahan, Learned APP accepts notice on behalf of the state respondent. Let steps be taken for service of notice upon the respondent number 2 in the manner prescribed, which is to be routed through the office of the Learned PP Assam. Steps within 2 working days. 2 days. List after 6 weeks. For
After
Up.
this, date will be given.
it's not, list after 6 weeks. For service report, as well as for filing objections, if any. You take steps immediately. 23 days is not a problem. We'll come down, but notice has to go.
Item 10.
Recusal.
Yes.
It is an appeal from jail lordship and the
I for,
jail lordship.
I for,
The IA for condoning the delay of 819 days lordship in preparing the appeal.
819.
Yes, sir.
Can POXO matter.
Oxo, same,
Yes.
huh? Same. Same. Be elder. Okay. Exam exact. You take steps through the PP. 6 weeks.
Seven.
Yes, Madam Katanier, what is this? I,
Yes, yeah, 574.
hmm?
574 days.
Delay,
Tell me.
Oxo.
Okay.
Okay, same. 574 days. এটা legal aid council, হ্যাঁ এটা কিন্তু এটা legal aid council. Or it is respond number 2 to informant. Shankar Deka. Yeah, no, respond number 2. Okay. Take steps.
Item 3. 10 minutes.
আছে নাকি মানুষ? Okay, it will, in view of, in view of the absence of the learned counsel for the appellant when the matter was called upon, comma, the same is adjourned to be listed on Friday. Miss Miss S. Jahan, learned APP is present. Item 3.
Item 12 for hearing.
I have a small prayer to make. I'm
Small prayer, you need not be, so you can raise your voice.
Yes.
Prayer is small, voice is not small.
Otherwise, I'm prepared this matter.
And otherwise, we are also ready to hear you.
Today only it is a bit difficult. Might be difficult.
What difficulty? Personal difficulty.
Yes, certain difficulty. Yes. Maybe tomorrow.
Birthday parties in the evening.
Not birthday party. No, not. Tomorrow, any day. Tomorrow, I'm ready.
Not in the dark.
Even tomorrow, I'm ready. The matter or day or Monday, whenever.
Morning, what work do you have except court? Okay. We will not ask you any embarrassing question. Okay, when?
Any day. Tomorrow, Tuesday also. Or
Tomorrow also we can have what, how many witnesses?
Yeah, not much.
Hmm?
Not much. 12. But
Well, conviction under?
under 302 and only on circumstantial evidence. No eyewitness.
Okay, we can have it tomorrow. No? Okay. Okay. Tomorrow is any day. Why?
Thursday.
Thursday. We have it tomorrow.
Thursday.
Okay. On the request made by Sri R. Sharma, learned Amicus curiae, the matter is adjourned to be listed for hearing tomorrow.
Obliged.
Miss B. Bhuyan, learned APP is present. Okay.
Obliged. Much obliged.
Okay, who is the other, who is Mr. Jadas? Jadas?
Oh, my.
Huh?
This is my.
Okay, okay.
Obliged.
Because there is another Jadas who is not well, so we thought to
Yes.
be.
Not a box.
Item 13.
Madam, what is your, yes, you don't have a birthday party today. You are ready? Okay.
10,
How many?
10 PW, 1 DW.
Why is it so thick?
Medical record, because insanity plea was taken, so a medical register and records are annexed with the paper book.
Okay, okay, okay. মোক এখন নতুন দিয়া নাই আছে ইয়াতে মোটা হলে ভাল অলপ সৰু ন এখন বেছি সৰু দিয়াচোন $302.
302. The allegation is that he had killed his mother. $201 is also there.
No witness.
No, I.
Informant is PW1.
Yes, Lordship. Lordship, date of incident is intermeeting night of 25.
Just a minute. PW1 is the informant.
Informant, maternal uncle of the accused.
His sister has been killed. Just give us 2 minutes. You're an Amicus.
Lord.
Madam Bhuya would be appearing. Yes, you can please proceed.
Lord. Incident, date of incident is intervening night of 25/6/2018.
25 and 26, or 24 and 25.
Yes, sir.
It was lodged on 25/6 at 4 p.m.
At 4 p.m. It was lodged at
So
4
it was
p.m.
on the previous night,
Incident was the previous night.
24, 25th night. The Ajahar is at page 4,
Page 4.
25/6. What is the name of the informant?
Informant is Jibon Bora. TW.
His name is Guno Prabha Bora.
Please read. Please read.
I have the honor to state that Sri Dhrupajyoti Bora, a resident of Do Parbatia Kaudor Supuri, beheaded his mother, our elder sister, Guno Prabha Bora, by means of a sharp weapon. Thereafter, he put the dissipated body in a concrete well of drinking water and kept the head buried in a nearby ditch. Thereafter, we learned from our neighbors that he had killed our elder sister Guno Prabha Bora by cutting her neck after torturing her at night. I therefore pray to take necessary action against the accused. So this is the Azhar Lord. Charges were framed under 302 and 201, and 10 PW is examined. 1 DW, the doctor of Lokapriya Gopinath Bardoli Regional Institute of Health, was examined as DW1. Case of the accused is a total denial lot. The plea of insanity was taken because earlier he sustained a head injury and a medical record was also there, but the learned court found that this doesn't come as under section 84.
It was discussed. Yes.
PW1, the informant Jibon Bora.
Page 8.
Page 8. Accused Dhrupajyoti Bora is my nephew. On 25/6/2018 at about 6 a.m., one Potongia, adjacent resident of my elder sister Guno Prabha Bora, informed me that on previous day in the evening time, quarrel took place between the accused and his deceased mother Guno Prabha Bora. He also informed me that
Potongia is PW3.
PW3.
Yes.
He also informed me that he had seen at around 4:30 a.m. that the accused put some garbage in his well, and till 6 a.m. he had not noticed the deceased, who usually used to go for walking at 5 a.m. On suspicion, Potongia informed me. Then I, along with my wife, went to the house of my elder sister and had seen many persons gathered there. We called Gaubura, namely Chulon, who informed police. At that time, accused was inside his house by bolting the door. Police came and on being asked, the accused opened the door. Thereafter, when police inquired the accused about his mother, then he coming out with a kukri, said that with this kukri he killed his mother and thrown the dead body in the well. Then police recovered the beheaded body of my elder sister. On being asked the accused, he said that he kept the head in a pit in the backside of his house. Accordingly, police also recovered the head of my elder sister from the pit. The accused and his deceased mother used to reside together. Then I filed the FIR. Police seized the said kukri, white scissor list Exhibit 2, and Exhibit 2 is my signature. Material Exhibit 1 is the said kukri. Police conducted inquest upon the dead body. And Exhibit 3 is the inquest, and Exhibit 3(1) is my signature. Cross. I had not seen the incident. I had no any visiting or touching terms with the deceased sister since last 7 years prior to her death. On 24/6/2018, I had not visited the house of my deceased sister. Before my arrival at the place of occurrence, about 100 people gathered there. On morning of 25/6/18, after arrival of the police, I entered into the house of my sister. I noticed blood stain marks near the door, but not inside the house. I could not remember whether the police had seen any blood-stained cloth from the house of the accused. I do not know if before arrival of the police, the villager had beaten the accused, but the accused was beaten by the villager in front of the police. Utpal Bora is my nephew who resided at Dosupuri. My deceased sister had cordial relation with Utpal Bora and she used to visit his house. On 25/6/18 at around 4 p.m., I lodged the FIR. Police came to the place of occurrence in the morning of 25/6/2018. The FIR was written by me as per dictation of one Bonia. In the FIR had not specifically mentioned that the accused had informed the police that he kept the dead body of his mother in the well and head in the pit. It is not a fact that accused did not inform police that he kept
The FIR was written by me as per dictation of
one Bonia.
I think it is
Potongia.
No, no,
Please.
I think it has been wrongly recorded. Why, the FIR was written by him, why
Yes.
should somebody else dictate? I think he had,
Maybe,
he
as
had
per my
dictated,
dictation,
Bonia had written
Written.
perhaps. That should have been
It-
the.
in the FIR, I had not specifically mentioned that the accused had informed the police that he kept the dead body of his mother in the well and head in the pit. It is not a fact that accused did not inform police that he kept the dead body of his mother in the well and head in the pit. My deceased sister owned 1.5 katha of Bari land along with a house. Now that property is lying abandoned. It is not a fact that I had occupied the said property after the death of my sister. Accused is the only son of my deceased sister. I cannot say whether prior to this incident, the deceased had filed any case against the accused with the police court or before Gampura. It is to my knowledge that the accused had made with a fatal road traffic accident and had taken him for his treatment to Guwahati. I do not know if since after the incident he had been suffering from mental disorder and undergoing
What is
treatment.
the fatal incident? What is the fatal incident?
Nearly fatal.
Fatal means one has to die.
Die.
What is the expression used? Fatal incident.
Fatal incident. If after the incident he had been suffering from mental disorder and undergoing treatment till date in LGBRMI test score. It is not a fact that in spite of knowing that the accused had been suffering from mental disorder since after the incident, today I willfully suppress that I do not know about this mental disorder. Today I have not seen blood stain in material exhibit 1. This type of kukri are commonly found in everybody's house in village. I have not noticed any specific mark on the material exhibit 1 regarding ownership of the kukri. Police seized the said kukri from the accused. It is not a fact that the seized kukri was not found in the hand of the accused. It is not a fact that material exhibit 1 is not belong to the accused. Jhulan Gampura is still alive. Till date, I have not prayed for bail on behalf of the accused. After 2-3 days of the incident, police recorded my statement. I had not specifically stated in my FIR or in my statement under section 161 CRPC why the accused had caused the death of his deceased mother. Near the house of the deceased, there are many houses including Kushal Shekhar Manoj Oja. There is boundary wall in the house of the deceased except the front entrance side. In front of the front entrance, there is a village path named the Sodabar Sukuri path and villagers used to use the said road frequently. I do not know if the accused went to Bombay for working there in the year 2013. I heard before 3 months of the incident that the accused went to outside the state for work. I do not know if when the accused returned from outside, he was detained in airport due to his mental disorder and subsequently the deceased mother had been to Bombay to bring him back from airport. Witness Rupamani Bora is my wife, Chittaranjan Bora and Utpal Bora are my nephew. The houses of Kotongia is adjacent to the house of the deceased on southern side. My house is around 1.5 kilometers away from the house of the deceased. I do not know if on 24/6/2018 at evening hours, the deceased went to the house of my nephew Utpal Bora. It is not a fact that we are on suspicion assaulting the accused implicated him in this case. The head of my deceased sister was severed from the body and except that I had not noticed any injury over the body. I noticed mark of blow over the severed head. I do not know the contents of Exhibit 3. The inquest report. In Exhibit 3, it is written that from the statement of villagers came to know that on 24/6/2018, she died. It is not a fact that on 25/6/2018 at about 6 a.m., one Kotongia did not inform me that on previous day in the evening time, quarrel took place between the accused and his deceased mother. Gunaprabha Bora, and he also did not inform me that he had seen at around 4:30 a.m. that the accused put some garbage in his well and till 6 a.m. he had not noticed the deceased who usually used to go for walking at 5 a.m. It is not a fact that the accused did not come out with a kukri in his hand, said that with this kukri he killed his mother and thrown the dead body in the well and head in the pit. Rather, he told that mother had gone to relative's house on 24/6/2018. It is not a fact that before arrival of police, villager retrieved the dead body. When I noticed the accused, he was wearing trousers and shirt. I did not notice whether there was any blood stain in the wearing clothes of the accused. I do not know whether police had seized wearing clothes of the accused or not. It is not a fact that I, along with the villagers and police, had assaulted the accused and compelled him to admit his guilt. It is not a fact that though the accused was not involved in the case and said that he had not committed any crime, we handed over him to police. It is not a fact that with intent to grab the property of the deceased and the accused, someone had killed the deceased and falsely implicated the only other member in this case. It is not a fact that the content of the FIR is without my knowledge and falsely filed the FIR. So what is in his deposition, Lordship? Many things he had not disclosed in the FIR, Lord. That's quarrel part, intimating about those things are not in the FIR. Although it was
Is it required? It is not required.
not required, but
It is not required.
may not be, Azhar may not a tale of this.
Time and again, Honorable Supreme Court has said FIR need not be an encyclopedia. It's just a narration of the basic facts to set the criminal law into motion. One line is enough. Okay. Yes.
PW2, Rupamani Bora, she is wife of PW1. One another thing I want to say that, Lordship, although there are many other neighbors are there, they were not examined. Monojoja, those persons who are the immediate neighbors, except this PW3, those persons were not examined. PW2, Lord. Accused Trupojyoti Bora is my husband's nephew. This is my husband's elder sister. On 25/6/2018 at 6 a.m., Ghanakanta Patongia, the adjacent resident of deceased, coming to my house, informed that he heard some quarrel in the house of the accused the previous night, and in the morning he had not seen the deceased, who was in the habit of walking at early morning around 5 a.m. He also informed that the accused put some branches of tree and garbage in the well. Then I informed other family members. Hearing about the incident, my husband went to the house of the accused, and after about 1 hour, I also went there. Villagers also gathered there and police came. From villagers, I heard that the accused admitted that he had killed his mother. The body of the deceased was found in the well, and the head was found in a pit in the backside of the house of the accused. From villagers, I also heard that when the body was found without head, then on being asked, the accused told that he thrown the head of his mother in a pit. I also heard that the accused killed his mother with a dagger of Mizdow. Cross. Out of fear, I had not seen the dead body. I also had not seen any weapon of offense. Since last 7 years prior to incident, we had no visiting or talking terms with the deceased or with the accused. It is a fact that the accused made with a road traffic accident and my husband took him to Guwahati for treatment. I do not know if after the said accident, the accused had been suffering from mental disorder and still he is undergoing treatment at LGBRIMH school. I do not know if the accused went to Bombay for work and subsequently he was brought back by the deceased from the airport for detaining him due to his mental disorder. After reaching the place of occurrence, I did not talk with the accused regarding the incident. I heard from the villager that the accused told that his mother went outside of the house on previous day for a visit. I had not seen the accused before he was put in the police vehicle. As I was at a little distance, so I did not notice if public had assaulted the accused. It is not a fact that I willfully suppressed the fact that before arriving of police, villager along with my husband had assaulted the accused and forced him to admit the guilt. In the house of the deceased, only she and the accused used to reside. It is not a fact that at present we are occupying the land of the accused. My husband and myself had not filed any bail application for the accused till date. Police did not record my statement. I do not know the reason behind the said incident. Patongia coming to my home informed my husband in my presence. It is not a fact that neither I was present when Patongia came to our residence, nor Patongia informed anything the way I narrated in my examination in chief. It is not a fact that from villagers I did not hear that the accused killed his mother. It is not a fact that from villagers I did not hear that when the body was found without head, then on being asked, the accused told that he thrown the head of his mother in a pit and that the accused killed his mother with a dagger or meat dao. It is not a fact that before arrival of police, the villager retrieved the body of the deceased from the well. It is not a fact that with intent to grab the land of the deceased, we falsely implicated the accused in the present case. It is not a fact that I falsely adduced evidence against the accused today before the court, and in spite of knowing the fact that the accused is not involved in the case, he has been planted falsely in the case. PW3 Lordship is Honakanto Potongia. I am the neighbor of accused Trupojoti Bora. The incident occurred on 25/6/2018 at around 10:11 p.m. On that day at around 8 p.m., I went to invite Bhakot for the Nam to be held in the next day of Namkar, and at around 8:30 p.m., I returned home. At that time, I heard quarrel between accused Trupojoti Bora and his mother Gunoprabha Bora. I heard crying of Gunoprabha Bora. On earlier occasions also, they used to pick up quarrel. Hearing cry of Gunoprabha Bora, when I inquired her from my campus what happened, she replied that her son Trupojoti Bora fell down dal prepared by herself, saying that it is not tasty, and hence she again prepared the dal. Then I asked her to come to my home if he is quarreling with her, but she refused, saying that she would remain in her house whether her son cut or kill her. Then I entered into my house. In the morning, I had seen Trupojoti Bora throwing some garbage in their well. Then I informed the brother of Gunoprabha, namely Jibon, about the quarrel on last night as well as throwing garbage in well. Then Jibon, along with 2-3 others, came, and on being inquired, Trupojoti Bora himself before villager admitted that he had cut his mother Gunoprabha with a kukri and throw the dead body in the well. Then the villager called Gaupura, and on being informed, police also came. Police brought out the dead body from the well. The torso of the dead body was found in a bag, and the head was recovered from a pit in backside of the house of the accused. Police took the dead body for post-mortem examination. I made statement before magistrate under section
I think
164.
the first date where this PW3 has mentioned should have been 24/6.
24/6.
He said 25/6
Yes, sir.
because he had gone to invite for the Nam on the previous evening, and the FIR was lodged on 25/6. So incident had happened in the wee hours early morning of 25/6, and the quarrel had happened on the previous
Previous
evening
night.
of 24/6. So I think 25/6
Yes,
should have been
Yes, it should be
24/6.
24.
Cross. I had not seen the incident. Manoj Oza and Kushal Deka are my neighbor beside the accused. Manoj Oza and Kushal Deka are still alive and are residing in our village. Police recorded my statement after 2 days of the incident. I gave statement before magistrate after about 2 weeks from the day of incident. So 164 is recorded after 2 weeks, and before police it's 2 days. Before magistrate, I had not stated that. I asked her to come to my home if he is quarreling with her, but she refused, saying that she would remain in her house whether her son cut or kill her. It is not a fact that before police I had not stated that. I asked her to come to my home if he is quarreling with her, but she refused, saying that she would remain in her house whether her son cut or kill her. Before magistrate, he had not stated, but before police, he stated that. It is not a fact that before police and before magistrate that I had not stated that. I informed the brother of Gunoprabha, namely Jibon, about the quarrel on last night. I cannot say who were the 2-3 persons who accompanied Jibon to the house of the accused after I informed Jibon. I had not entered into the house of the accused while Jibon and others inquired the accused about his mother, but I heard from outside what the accused stated before them. It is a fact that before police and magistrate, I did not state that Jibon along with 2-3 others came, and on being inquired, Trupojoti Bora himself before villager admitted that he had cut his mother Gunoprabha with a kukri and thrown the dead body in the well. It is not a fact that today, for the first time, to implicate the accused in this case, I stated falsely that Gibbon along with 2-3 others came and on being inquired, Dhupajyoti Bora himself before villager admitted that he had cut his mother Gunoprabha with a kukri and throw the dead body in the well. After about 1 hour of arrival of Gibbon, police arrived at the house of the accused. About 150 to 200 persons gathered at the place of occurrence. It is not a fact that the person gathered at the place of occurrence had assaulted the accused, but they had pushed the accused, asking why he had killed his mother. It is not a fact that the villager assaulted the accused and pressurized him to admit his guilt. The torso of the deceased was kept in a white color plastic bag, but I had not seen the said bag as it was immediately taken away by the police into the vehicle. I do not know whether the bag was seized or not. It is not a fact that the body was not found in the bag. For many days, the villager discussed about the incident, but I did not discuss about the incident with the villagers. I was brought before the court by 2 police officers who came to the place of occurrence on the date of incident. Before magistrate, I stated that at early morning, seeing the accused throwing some garbage in the well, I suspected that he might have killed his mother and threw the dead body in the well. Before magistrate, I also stated that on being inquired, the accused told Gibbon Bora and the villager that his mother went out to visit someone on previous day. I also heard the same statement from the accused. Before police, I had not stated that when police came, the accused attempted to attack police with kukri. Before police, I had not stated that on being inquired by police, the accused admitted before police that he had killed his mother and thrown the dead body. Before police, I had not stated that the accused admitted that he has kept the head of his mother in a hole near a latrine and put garbage upon it. It is not a fact that before police I stated that there was quarrel between the accused and his mother for last 1 month with regard to a plot of land, and his mother told that she selling the said land will open a shop for the accused and with the remaining amount will build a house, but accused demanded the whole money. It is not a fact that before police I did not state that we had seen that the accused had washed his backside veranda. I do not remember whether I informed Gibbon about quarrel between mother and the accused on the previous night or having thrown away the dal by the accused. It is not a fact that I have willfully suppressed the fact of quarrel of previous night and throwing the dal, as no such incident took place on that night, as the mother of the accused was not present at that relevant point of time. It is not a fact that in connivance with the police, I had made the above concocted fact to somehow book the accused in the case. The house of the accused is bounded by wall on 2 sides. In my side, it is 5 feet height, and Decca's side, it is 10 feet height. My house is in the southern side of the house of the accused, and Decca's house is on northern side of the house of the accused. On the eastern side, there is a village road, namely Sodar Suguri Pot. The entrance door of the house of the accused is on eastern side. The house of the accused is comprised of 3 rooms with brick wall, and it is a Assam type house. On the day of incident, I along with my wife and son were at home. On the day of throwing dal, the deceased was wearing white color mekhla sadar. In the morning, I had not seen the dead body, so I cannot say what she was wearing at that time. I cannot say which color mekhla sadar was wearing by my wife on the day of incident. It is not a fact that house of the accused is not visible from my house, and hence on the night, neither I had seen the deceased nor any conversation took place between me and the deceased. Accused resided with his mother. He is a bachelor. I do not know if the accused met with an incident in the year 2012 and was admitted in Guwahati for his treatment. I do not know that since after the incident, the accused had been suffering from mental illness. I know that he is working in a company. I know that prior to this incident, the accused was held up at Bombay Airport and he was brought by his mother from Bombay Airport. Explanation. Accused was held up at Bombay Airport for entry. I do not know for what reason he was held up at Bombay Airport. After arrest of the accused, I did not inquire about him or whether he was taking medicine during the period of detention in jail. Now the land of the deceased is vacant, none remained there. It is not a fact that earlier I want to purchase the land of the accused, but it was given to some other person. It is a fact that the deceased took consideration amount of rupees 50,000 from another person for sale of her land. It is not a fact that as I was having grudge against the accused for not allowing me to purchase the land of the deceased, hence I deposed falsely against the accused. I had not seen any seizure of blood-stained cloth of the deceased by police. I also had not seen any blood-stained cloth. I did not enter into the house of the accused on the day of incident. I had not seen any mark of blood stain at the place of occurrence. I had seen the kukri when police brought it from the house of the accused, but there was no any blood stain in the kukri.
Just a minute. ma'am.
Look at page 91.
91, sir.
This is the 164 of PW3.
Mhm.
The pattern here.
Yes.
The date has been properly written, 24.
Yeah, here's 24.
Because this was recorded immediately. This was recorded on 36.
Yes.
And the incident had happened on
It has to be 24.
24.
Mm.
And here, this
Because-
narration and his deposition as PW3 is almost matching.
Mm.
Consistent.
Okay.
And this has been proved.
Mm.
164 has been proved. Yes, 164 statement is proved as exhibit 4. Exhibit 4.
This is exhibit 4. Mm.
Then we see from here in the next page, page 92. Next page, the distance at the height of the water informant from the place of the deceased and apparent to 1 kilometer, not too much. I was just wondering, it is not 100
Mm.
just third line from the top.
Mm.
I was not 1 kilometer now. We just noted.
The distance of about 1 kilometer.
So the brother of the deceased, the maternal uncle of the deceased, 1 kilometer. So this
Mm.
PW3 is a neighbor.
Mm.
He had gone to his house and found. That has been said by PW1, they informed as well as his wife PW2.
Mm.
So I heard quarrel on the previous evening.
Mm.
Morning at 4 o'clock when I found him throwing some garbage in the way, like and some dishes.
Yes.
6 o'clock he goes out for a walk. I did not find her going out for a walk. Then I have found him.
It is not a fact on that I have given different statement before police, magistrate and before the court today. It is not a fact that on the day of incident, the deceased was not in her house. I do not know the name of our Gaupura. It is not a fact that on the night the deceased was not wearing white color mekla sadar. It is not a fact that I had not seen the accused throwing garbage in the well. It is not a fact that the accused did not admit before police and villager that he had killed his mother. PW4 on Chittoranjan Bora. He is a cousin of the accused. So Dipon Bora is my maternal uncle, so he is a cousin of the accused. I know accused Suppository Bora. Informant Dipon Bora is my maternal uncle.
Just a minute. Okay.
I know accused Suppository Bora. Informant Dipon Bora is my maternal uncle. On 25/6/2018 in the morning, my maternal uncle Dipon Bora informed me about raising halla in the house of Gunaprabha. And in the morning, accused Suppository thrown out some garbage in his well, and the fact was informed to Dipon by immediate neighbor of deceased Gunaprabha Bora. Immediately after knowing the incident from the said neighbor, Dipon Bora reported the matter to us. Then I, along with my cousin brother Utpal Bora and some villagers, came to the house of Dipon Bora, and from the house of Dipon Bora, we went to the house of Gunaprabha. At that time, some persons were there. Dipon Bora informed Gaupura. Accordingly, the Gaupura informed police. At that time, accused Suppository was inside his house. On being asked by police, accused Suppository told that he had a quarrel with his mother, and thereafter he inflicted kukri blow to his mother Gunaprabha. After arrival of police, the accused came out from his house and admitted his guilt in presence of police. The beheaded body of Gunaprabha was recovered from the well. On being asked, the accused told that he thrown out the head of the dead body in a ditch near the latrine. In the house of the deceased, he, along with the accused, resided. Cross. Accused Drupajyoti is my cousin. My house is about 2 kilometers away from the house of the accused. I have no visiting term in the house of the accused. As I had no visiting term in the house of the accused, hence I have no knowledge about the happening in their house. In the morning at around 7 a.m., I was informed by my maternal uncle Jiban Bora. Jiban Bora rang me from his house. I went to the house of Jiban Bora at around 7:30 a.m. At that time, Jiban Bora was alone in his house. We reached the house of the deceased at around 8:15 a.m. I do not remember at what time police reached the place of occurrence. Before arrival of police, about 100-150 persons gathered there. It is not a fact that before arrival of police, villagers had assaulted the accused. On the very day police recorded my statement, I myself heard when the accused told that he committed murder of his mother. It is not a fact that neither the accused told that he committed murder of his mother by a kukri, nor I heard the accused admitting his guilt. I do not know how many persons heard when the accused admitted his guilt. I do not know the name of the Gaubura who informed police. I know that in the year 2012, accused met with a road traffic accident. I do not know if he was undergoing treatment and mental hospital test for prior to the incident. After the incident, I did not go to meet the accused. I do not know if the accused is undergoing treatment during his jail period. Gunaprabha was a widow. I do not know whether the deceased lodged any FIR before police or court against the accused prior to this incident. I do not know any person named as Dhanakanta Patankia. I did not talk with the person who informed Jiban Bora first about the incident. I did not enter into the house of the accused on that day. I have not seen from where police recovered the seized kukri. When we reached the house of the deceased, I had seen the accused. At that time, he was wearing long pants and shirt. I had not seen any blood stain on the wearing apparel of the accused. I do not know who presently reside in the house of the accused. I did not hear if the accused told before the villager that on the previous day his mother went for visiting someone. It is not a fact that in spite of knowing that the accused told before the villager that on the previous day his mother went for outing, today I depose falsely that I did not hear. I do not know whether prior to the incident the deceased went to Mumbai to bring back the accused. It is not a fact that when the accused was asked by police about the head of the dead body, he did not tell that it was in a ditch near the latrine. I do not know if on 25/6/18 accused first informed police to came to his house as the villager gathered in his house and some untoward incident took place. It is not a fact that before police I did not state that Jiban Bora was informed by the immediate neighbor of the deceased about the incident, and thereafter Jiban Bora rang me and informed the same to me. It is not a fact that Jiban Bora did not inform me about the incident, and on that day the accused thrown garbage in his well. It is not a fact that before police I did not state that the neighbor of the deceased informed about the incident. I do not know if on the previous day of the incident the deceased went out from her house for visiting someone. It is not a fact that I falsely implicated the accused in the case. Then PW5, he is also a another cousin of the deceased lord.
Cousin of the deceased, no, cousin of the appellant.
Appellant.
Because Utpal's name has been
Yes,
uttered
ma'am.
by
Jiban.
Chittaranjan also.
Yes.
Chittaranjan, the earlier.
Yes. I know accused Drupajyoti Bora. I also know deceased Gunaprabha Bora and the informant Jiban Bora. The incident occurred on 24/6/2018. On the next day of occurrence, that is on 25/6/18, my maternal uncle Jiban Bora informed me that the neighbor of the deceased informed him that there was commotion at night in the house of the deceased, and in the morning accused Drupajyoti thrown out garbage in his well, and he had not noticed the deceased, who usually woke up at 5 a.m. Then I, along with our villagers, came to the house of the accused. At that time, the accused was inside his house by closing the door. Many persons gathered there. Then Jiban Bora informed the Gaubura. Accordingly, Gaubura informed police. Police came and called the accused. Then the accused came out from his house, and on being inquired about his mother, the accused told that he had cut his mother with kukri and thrown the body in the well. Accordingly, police recovered the beheaded body of the deceased, which was kept in a gunny bag. On being asked about the head of the body, the accused told that he threw the head in a ditch near the latrine. Accordingly, the head was also recovered. Thereafter, police took the accused to the police station. Accused also produced.
What is the meaning of this? Accordingly, you had just already read. Accordingly, police recovered the beheaded body of
Of the deceased.
beheaded body
Yes,
of the which was kept in a gunny bag.
gunny bag.
The police says after recovering they had kept in a gunny bag or it was found in a gunny bag.
According to this line, this was kept in a gunny bag.
No. There can be two meanings.
Yes.
One is recovering and putting in a gunny bag, or one is recovering
That he
along
had,
with
Already in the gunny bag.
gunny bag. Probably it was already in the gunny bag.
Yes. On being asked about the head of
Was
the body,
any memo prepared on section 27 leading to discovery?
leading to discovery, not there.
No memo prepared. What about the deposition of the IO?
IO PW.
We may not be insisting on a exact memo of 27.
There is,
But
I have not
if
found
in the
it.
evidence it is found that he has led to the
Yes.
discovery, then
27.
then what did the IO say? How was the head recovered?
As shown by the accused, that much is there.
That's said, okay.
That much.
Oh.
Then thereafter, police took the accused to the police station. The accused also produced the kukri from inside his house and told that by the said kukri he killed his mother. Material exhibit 1 is the said kukri. Police seized the said kukri by Cizerly so and so. I was also present during conducting inquest on the dead body. I heard that the accused consuming liquor sometimes used to pick up quarrel with his mother. Cross. I have not given statement under section 164 CRPC. Accused is my cousin brother and this is Gunaprabha is my paternal aunt. My house is about 2.5 to 3 kilometers away from the house of the deceased. As I am a mason, I used to go out for work from my house at 8:30 a.m. and used to return home at 5 to 7 p.m. I have no visiting term in the house of the deceased, hence I cannot say about the happening in the house of the deceased. The accused is the only son of the deceased. On 25/6/18, police recorded my statement. It is not a fact that before police I did not state that Dibon Bora informed me that the neighbor of the deceased informed him that there was commotion at night in the house of the deceased and in the morning accused Drupadi thrown out garbage in his well and he had not noticed the deceased who usually woke up at 5 a.m. I do not know the name of the Gaupura. I do not know if the accused was the first person who informed police that there was gathering of people in front of his house and some untoward incident took place in his house. It is not a fact that before arrival of police, the villager brought out the accused from inside his house and by assaulting pressurized him to admit his guilt. I did not enter into the house of the accused. I have not heard what conversation took place between the accused and police. It is not a fact that on being tortured by police as well as tutored by police as well as learned prosecution counsel, I have falsely stated that the accused admitting his guilt regarding committing murder of his mother by a kukri and keeping the dead body in well and the head in a ditch near the latrine. On that day, I have seen the seized kukri. It is not a fact that on so-and-so police did not seize the kukri and it was seized on 26/6/18 from some other place. It is not a fact that seized kukri is no way connected in death of the deceased. I know that some years ago of the incident, accused met with a road traffic accident for which he took treatment at Guwahati. It is not a fact that after the treatment for the said accident, the accused had been suffering from mental illness and at the time of incident also he was suffering from mental ailment and still he is undergoing treatment. After the incident, I did not meet the accused. I do not know if presently the accused is undergoing treatment at mental hospital. I do not know if prior to the incident, mother of the accused lodged any complaint before the court, police or Gaupura. It is not a fact that before police I stated that from Dibon Bora, I came to know that on being asked, the accused told that on the previous night, his mother had gone for visiting somewhere. It is not a fact that before police I stated that the neighbor suspected that quarrel took place between the accused and his mother. I know Ghonakanto Potongkia, the neighbor of the accused. I do not know if Ghonakanto is a broker of land. Presently, none reside in the land of the deceased. After the incident, I did not go to the land of the deceased. I came to know that the deceased land was supposed to be sold to someone. It is not a fact that before arrival of police, the villager brought out the accused from inside his room and by assaulting pressurized him to admit his guilt. It is not a fact that the accused is not involved in this case in any way and I have falsely implicated him. It is not a fact that the accused did not admit his guilt to anyone. It is not a fact that on the night of 24/6/18, deceased was not at home. It is not a fact that I have adduced evidence falsely. Next, PW6, he is the PDP secretary, Lordship. I know the accused Rupasati Bora. This is Gunaprabha Bora was the mother of the accused. Incident occurred on 24/6/2018 at night. We came to know about the incident on 25/6/2018. Usually, deceased was an early riser woman, but on 25/6/18, when she was not noticed by the neighbor, they inquired the accused about his mother, but the accused remained silent. At the very morning, the accused was found hearing music at full volume after returning from salon by cutting hair. Seeing the accused in that situation as well as when his mother was not noticed, the neighbor asked him about his mother. Though at first the accused said nothing, but after some time he admitted that he had killed his mother. Then we informed police. Accordingly, police came and during interrogation, the accused, admitting his guilt, stated that he killing his mother threw the dead body in the well. Fire brigade also reached the place of occurrence. Police recovered the dead body from the well. The dead body was found covered with garbage, branches of tree, etc. Beheaded dead body was in a jute bag. So here he said it is a jute bag. Earlier it is candy bag.
Yes.
To prevent the accused from public assault, police took the accused from the midst of public. In the police station, on being asked about the head of the, so here it is in the police station, on being asked about the head of the dead body, the accused told that he had thrown away the head in a pit in backside of his house. According to him, it was stated in the police station. I brought out the head from the pit.
Has he said anything about the distance where he was staying in the village from the house of the accused?
House of the accused and
The distance of his place of residence from the house of the
this
accused?
PDP secretary.
Yes, yes.
PDP secretary, he had not stated, but PW 1 and 2's house is 1.5 kilometers.
Because, no, if you come to the sixth line from the
Yes.
top, at the very morning, the accused was found hearing music
Yes,
at full volume and after returning from saloon, after cutting hair.
Lord.
It appears that he has himself,
Later
no,
arrived.
he has himself heard. So unless he is a resident who is in the immediate vicinity, he will not hear the music. So that is why whether this deposition is on the basis of some information received by him, or was he himself a witness to this hearing?
He reached the place of page 31,
Yes.
third paragraph. I reached the place of occurrence at 9 a.m. and police reached the place of occurrence before my arrival.
No, that is okay. That the accused was found hearing music and
Lord.
was found. Did
Yes.
he find or did somebody else find or and informed him?
That is not here, but other witnesses have not stated. Even Ghonakanto have not stated about this food. That and saloon lordship at that early hours. That is also around 5. He suspected.
No, this was not at 5.
No.
Ghonakanto had gone to the place of Jibon to inform. That was after 6 a.m. Thereafter, Jibon by telephone informed 2 of the cousins, namely PW
4 and
4
5.
and PW 5. PW 4 says that he first went to Jibon's house and together came to the house of the accused. 5 says he directly came to the house of the accused. By that time around, it was 9 o'clock. And people had already gathered.
Police also arrived.
Police had arrived. But VDP secretary, he says that he heard.
Yes.
Did he hear himself or did he get this information from somebody else? That is what we are trying to understand. Okay, please proceed.
So the incident cross is there. I am reading. I brought out the head from the
No,
pit.
this fourth line indicates that he was not present at that time, because you see, read the fourth line, usually at page 29.
Yes,
Usually, have you got fourth
yes,
line?
Lord.
The deceased was an early riser woman, but on 25/6,
Yes.
when she was not noticed by the neighbors,
Yes.
he did not say that I did not notice him. They inquired. They accused about the murder, but the accused remained silent. He has not stated that he inquired. He
Lord,
stated the villagers has
The
inquired,
neighbors.
neighbors.
It was not inside the gun.
Oh,
Electronic was for evidence of.
Hmm.
It was not wrapped in gunny bag while the dead body was found. PW8,
page
page 40.
40.
Yes. It was wrapped by some old bag, but somewhere I have found it was lying like that,
Where is page 40? 40.
down below.
Body was wrapped by some old
Last line,
bag.
the body was wrapped by some old bag. I
Bag.
did not seize the old bag. The head was wrapped by old polythene. I did not seize the said polythene.
Old, it was wrapped by a old bag, gunny bag, jute bag. It's
No, but it was wrapped. It was while it was found, it was wrapped or not. Somewhere I have found it was not wrapped.
I was evidence. We have to go, Lord.
Yes.
He is a resident of Do Parbotia Sonari Gaon, and the incident took place in Do Parbotia Haudor Supuri. So distance is 200 meters. Lordship. CDP secretary is a resident of another Supuri.
just a minute. No, 41, I think he's clarified, page 41. He has denied the suggestion. I think there is no confusion regarding the gunny bag thing. 41, second line. It is not a fact that the body as well as the head of the deceased was not wrapped by any bag, so that
That's
I could not able to seize the scene. Okay.
I brought out the head from the pit. Thereafter, the body along with the head was taken to civil hospital for post-mortem examination, and I also came there. But the body and head was sent to TMCH for post-mortem examination. At TMCH, when the head was washed for post-mortem examination, then I noticed 5-6 mark of kukri blow on the head. The relation of the accused with his mother is good, but sometimes he used to commit nuisance with his mother. Cross. I am the VDP secretary of Sonari Gaon. The incident occurred in Do Parbotia's Haudor Supuri. Sonari Gaon is about 200 meters away from Do Parbatia house of Sukri. Accused is not my relative. I had not seen the incident. After 1 week from the date of incident, police recorded my statement at the police station. I identified the dead body at the time of postmortem only. I only accompanied the police. It is not a fact that I neither identified the dead body nor I had been to the hospital along with the dead body for postmortem examination. I had not signed in the inquest report. At the time of conducting inquest, I was present there. At the time of conducting inquest, I noticed injury mark over the head of the deceased. It is not a fact that neither I was present at the time of inquest nor I had noticed any injury mark over the head of the deceased. It is a fact that before police I did not state that usually the deceased was an early riser woman, but on 25/6/2018, when she was not noticed by the neighbor, they inquired the accused about his murder, but the accused remained silent. It is a fact that before police, I did not state that at the very morning the accused was found hearing music at full volume after returning from saloon by cutting hair. Seeing the accused in that situation as well as when his mother was not noticed, the neighbor asked him about his mother. Though at first the accused said nothing, but after some time he admitted that he had killed his mother. It is not a fact that on being tutored by prosecution, I added the above two statements falsely before the court.
This contradiction he has admitted.
Lordship, he had
It
admitted.
is a fact that.
Not stated before
not
the
stated. Okay.
before the court today for the first time, and no such incident took place the way I narrated today before the court. I reached the place of occurrence at 9 a.m. and police reached the place of occurrence before my arrival. There was a talk between the police and the accused within the house of the accused. At that time, Prahlad Hazarika, my two brothers Biswajyoti Bonia and Sunit Jyoti Bonia, and others were present there. When the police interrogated the accused, about 40-45 people were present inside the house. I had not heard what the accused stated before the police. At first, the neighbor of the accused informed the maternal uncle of the accused about the incident. The maternal uncle of the accused reached the place of occurrence before me. It is not a fact that the accused did not state that, though at first the accused said nothing, but after some time he admitted that he had killed his mother. It is not a fact that the accused stated nothing before the police. It is not a fact that before police I did not state that during interrogation by police, accused admitting his guilt stated that he killing his mother threw the dead body in the well. It is not a fact that the accused did not state that during interrogation by police, the accused admitting his guilt stated that he killing his mother threw the dead body in the well. I had not heard that the accused was the first who informed police to save him from public assault that villagers suspected him of killing his mother. It is a fact that I did not state before police that in the police station on being asked about the head of the dead body of the accused, the accused told that he had thrown away the head in a pit in backside of his house. But I stated this fact before police.
What is the meaning?
Yes, sir. It is a fact that I did not state before police that in the police station on being asked about the head of the dead body, the accused told that he had thrown away the head in a pit in backside of his house. But that means he himself has stated that.
No, this statement was made not in the police station, but maybe earlier. That was what.
It is not a fact that when the accused was taken to the police station after interrogating him at the place of occurrence, again he was not interrogated at the police station wherein he has stated the above stated fact. It is a fact that before police I did not state that at PMCH when the head was washed for post-mortem examination, then I had noticed 5-6 marks of kukri blow on the head. It is not a fact that on being tutored by prosecution, I have stated falsely the above statement for the first time before the court today. Accused was the only son of the deceased. The father of the accused is still alive and he resided separately since long because he entered into second marriage. The accused met with an accident wherein he sustained severe injuries and was in the verge of death and had taken treatment at Guwahati. I do not know whether the accused is undergoing mental treatment from jail. I know Ghanakanta Patankia, he is a service holder. It is not a fact that he is a land broker. At present, the land of the deceased is possessed by none. Prior to the incident, the deceased and the accused executed an agreement to sell the land with a broker of Ketekibari whose name I do not know, and also took an advance amount of rupees 50,000 from the said broker. But still the possession of the land was not handed over to the broker. It is not a fact that today I deposed a different story from the statement before the IO. It is not a fact that I know nothing about the incident as I am the PDP secretary, hence police cited me as a witness in this case. I know that the accused was apprehended by police at Mumbai airport and the deceased mother took the initiative to bring the accused from Mumbai. Not a fact that I deposed falsely.
Why was he apprehended by police at Mumbai airport?
Accused.
No, accused, yes.
Why that is not
No, this apprehension came for the first time. Earlier, there are materials to show that the deceased had gone to the airport to fetch her son. But
Yes.
first time the apprehension by Mumbai police
yes.
had come. Mumbai airport. Okay.
Next is the PW7 is the medical evidence. This opinion, in my opinion, death was instantaneous, resulting from the injuries sustained over the neck. All the injuries were antemortem and caused by sharp cutting weapon, except the injury number 6, which was caused by blunt force impact and homicidal in nature. So, injury number 6 is contusion of size 4 into 3 centimeter present over the left side of the face. Approximate time of death is 12 to 24 hours at the time of examination. Examination was done on 25/6/2008. Eight is
How many injuries?
Lordship,
How many injuries?
6
6.
injuries. 5 are by sharp weapon and 1 is by blunt force impact.
Which one blunt?
6 numbers. Contusion of size 4 into 3 centimeter present over the left side of the face.
Now, apart from the first injury,
Yes.
which is a full thickness chop,
Yes.
would present at the neck, separating the head from the body. Thereafter, on the forehead, there is one injury incised.
Yes.
On the left side of the forehead, another injury 3 into 1. Another injury 6 into 2 on the left frontal parietal region.
3.
Another 3 into 2 on the right frontal.
Second page 35, he is stating about 3 injuries. Again, external appearance and there are 3 injuries. A full thickness of the first one. Then second is inside wound of size 2 into 1 centimeter muscle deep present over the frontal lateral aspect of right foot, 2.5 centimeter front of the lateral malleolus of right foot, and 3 is the same. No, 3 is not same. Contusion of size 4 into 3 centimeter present over the right shoulder. But here it is in the left side of the face. 4 into 3 centimeter. So 6, here it is came to 3.
No. Madam, there are 2 parts. The head is separated. The later part regarding the 3 injuries is on the torso. There is no head. So the question of having finding injuries on the forehead would not come in these 3 injuries.
It's in the body.
Because if you read external appearance, a body of a female person without the head. This was on the torso. Have you got it? Page 35.
Page
Ex- 35 is external injuries. How does
Yes.
it start? A body of a female person without the head. Okay.
So, and the first one is a head of a female person without the body.
Yes. Now, first external is the head.
Yes.
The head has 6 number of
6.
injuries. The body has 3 number of injuries.
So these 3 is included.
This first injury on the body as well as on the head, because the head has been chopped off. And the contusion is on the right shoulder.
Right.
Have you got?
Yes.
That contusion is in the head.
In the
This
left.
contusion is the right shoulder. except injury number 1, which is a common injury, the others are separate. So in total, there are 8 injuries.
8. PW8, IO lot. On 25/6/2018, I was working as in charge of police at Lalmati Police Outpost under Tezpur Police Station. On that day at around 8:20 a.m., I received an information from Tezpur control room that they were intimated that a villager of Do Parbotia Hautos Tukuri kept confined a boy in his house. On receipt of the information, I made the GT entry number so-and-so and went to the place of occurrence along with my staff. I found the accused Trupojoti Bora inside the house, locking the door from inside. I asked the accused to open the door. Then he opened the door, and on being asked, he reported that on the night he had quarreled with his mother regarding preparation of meal, and then being angry, he gave kukri blow to his mother over neck. On inquired him about the dead body, he told that he threw the dead body in a well. Then I proceeded to the well and had seen some garbage and branches of tree in the well. I called SDRF and removed the garbage from the well and found the beheaded body of the deceased. Prior to arrival of SDRF, I seized a kukri from the house of the accused as shown by him. Exhibit 2 is the scissor list and Exhibit 2-3 is my signature. That on being asked about the head of the deceased, the accused had thrown the head in a pit. Then I informed OC Tezpur to conduct inquest upon the dead body. Then Circle Officer Tezpur conducted the inquest. I prepared the sketch map of the place of occurrence. Exhibit 8 is the sketch map and Exhibit 8-1 is my signature. I recorded the statement of witness at the place of occurrence. I arrested the accused. I also sent the dead body for postmortem examination to TMCH. On the same day, I received a FIR from one Jibon Bora and I sent the same to Tezpur Police Station for registering a case. Accordingly, OC registered a case and I was enrolled to investigate the case. I sent the witness Dhanakanta Patangia to the court for recording his statement under Section 164 CRP. Material Exhibit 1 is the seized kukri. On conclusion of investigation, I submitted charge sheet against the accused Trupojoti Bora under Section 302 and 201 of IPC. Cross. The place of occurrence is around 4 km away from the Lalmati Police Outpost. Tezpur Court is 3 km away from Lalmati Police Outpost. Exhibit 7 is made at 8:20 a.m. and then I had been to the place of occurrence and initiated investigation of the case. FIR was received at 4 p.m. on 25/6/2018. Around 100 people gathered at the place of occurrence. In Exhibit 7, it has been written that the villagers of Hautos Tukuri has kept confined a boy in his house. I do not know the name of the person who informed police through so-and-so. After seeing the public gathering, which turned into a mob, and to rescue the accused from lynching, I called an additional force. Accordingly, additional force came. It is not a fact that accused was assaulted by public when I reached the place of occurrence. At 10:30 a.m., the accused was taken to the Tezpur police station from the place of occurrence. Before producing the accused in court, he was examined by doctor. As per report, doctor found injury on the body of the accused. In the requisition of Tezpur police station, it is mentioned that the accused person had been badly assaulted by the local people at the time he was caught. I produced the accused in the court on 26/6/2018 at 12:40 p.m. I did not pray before the court for recording confessional statement of the accused person. In the FIR, it is not mentioned that the accused confessed his guilt. In the FIR, it is not mentioned that witness Dhanakanta Patangia had seen the quarrel between the mother and the accused. It is not a fact that the accused did not state before me that on the night he had quarreled with his mother regarding preparation of meal, and then being angry, he gave kukri blow to his mother over neck. On inquired him about the dead body, he told that he threw the dead body in a well. It is not a fact that the accused was not interrogated by me at the place of occurrence, as because the villager tried to lynching on a suspicion to have committed the incident, and to rescue he was immediately shifted to the police station. I had not found any blood stain of the deceased at the place of occurrence, as it was already washed. The accused and the witnesses told me that the blood stain was washed by the accused. It is not a fact that neither the blood stain was washed by the accused nor it was reported by any of the witnesses. I did not find any blood stain inside the house of the accused. I neither seized any wearing apparel of the accused and deceased nor it was sent to FSF. I did not send the seized kukri to FSL. On 25/6/18 at 9:15 AM, I seized the kukri from the place of occurrence and I made shown the kukri in the court on the next day at 1:20 PM. I am aware of the fact that any seized article has to be produced in the court within 24 hours from the time of its seizure. So that 24 hours was not there.
Yes, please come again. What is it?
This on 25/6/18 at 9:15 AM, I seized the kukri from the place of occurrence and I made shown the kukri in the court on the next day at 1:20 PM. I am aware of the fact that any seized article has to be produced in the court within 24 hours from the time of its seizure. So this he had seized it on 9:15, so he produced it at 1:20 PM. No, it's there, PM, same day. It is not a fact that the kukri was not seized by me on 25/6/18, and I myself placed the weapon in this instant case to implicate the accused in the present case, and so it was not sent to FSL and not produced it before the court within time. I did not take steps for collecting fingerprint of the seized weapon and to match with the accused fingerprint. I did not seize any eatable cook item from the house of the accused. The inquest was conducted at the place of occurrence at 10 AM. In the sketch map, I had not shown the place where from the kukri was found. There is no any specific marking which suggests that the kukri belongs to the house of the accused. I have not recorded the statement of Kushal Deka and Manoj Oza as shown in the sketch map, as they replied that they knew nothing about the incident. I also did not examine the Gaupura of the village. Cross-examination, further cross-examination. As per the sketch map, there is boundary wall on the northern and southern side of the place of occurrence. In the sketch map, I did not mention the height of the boundary wall. There was no grill above the boundary wall. In the northern side of the boundary wall, the house Kushal Deka, and in the southern side, the house of Ghanakanta Patongia are situated. The main entrance of the house of the deceased is in the eastern side. There is no any boundary wall in the western side of the house of the deceased. The body was wrapped by some old bag. I did not seize the said bag. The head was wrapped by old polythene. I did not seize the said polythene. It is not a fact that the body as well as the head of the deceased was not wrapped by any bag, so I could not be able to seize the same. On 36/18, I sent witness Ghanakanta Patongia to the court for recording his statement under section 164 CRPs. I had not given any writing before the court for the said 2 days delay. The seized weapon was kept inside the house of the accused at the side of the wall. It is not a fact that the seized weapon was not seized from the house of the accused, nor it was used in the LS crime. The deceased Gunaprabha Bora before this incident had not lodged any FIR against the accused son complaining any quarrel with her. Witness Ghanakanta Patongia did not state before me that I asked her to come to my home if he is quarreling with her, but she refused, saying that she would remain in her house whether her son cut or kill her. Witness Ghanakanta Patongia did not state before me that I informed the brother of Gunaprabha, namely Jibon about the quarrel on last night. Witness Ghanakanta Patongia also did not state before me that there was quarrel between the accused and his mother for last 1 month with regard to a plot of land, and his mother told that she selling the said land will open a shop for the accused, and with the remaining amount will build the house, but the accused demanded the whole money. Witness Ghanakanta Patongia also did not state before me that we had seen the accused had washed his backside veranda. Witness Chittaranjan Bora did not state before me that Jibon Bora was informed by the immediate neighbor of the deceased about the incident. Witness Chittaranjan Bora also did not state before me that the neighbor of the deceased informed me about the incident. Witness Utpal Bora did not state before me that the neighbor of the deceased informed him that there was commotion at night in the house of the deceased, and in the morning accused supposedly thrown out garbage in his well, and he had not noticed the deceased, who usually woke up at 5 AM. Witness Trupajoti Bonia did not state before me that during interrogation by police, accused admitted his guilt, that he had killed his mother and thrown the dead body in the well. During inquest, I was present there. It is not a fact that without finding any material against the accused, I submitted charge sheet on suspicion, and also the deceased was not present at her residence on the night of incident. It is not a fact that the investigation was not done in accordance with law. PW 9 is regarding the 164 statement of Ghanakanta Patongia, and PW 10 is another in the circle officer who conducted the inquest. So here, third time, the dead body was PW10. Third time, the dead body was recovered from a well on the compound of Subhajyoti Bora. Both the hands and legs were closed and wearing sadar, petticoat, and blouse. Height of the body was approximately 5'5". Neck cutted fully, hand pale, no injury seen, chest, no injury seen. On the same day, on same GD entry number, I also conducted inquest upon a head of a female person in the compound of the deceased, Gunaprabha Bora, complexion fair, aged about 50 to 52 years, so and so, neck cutted, separated. Cross. I went to the place of occurrence at 10 a.m. for conducting inquest upon the dead body. Inquest was conducted at the place of occurrence. Inquest of the body fight so-and-so was conducted in presence of witness Utpal Bora, Jipon Bora, and Chittaranjan Bora. At the time of conducting inquest, a large number of villagers were present. In Exhibit 3 at the foot, I mentioned that as per person of the villager, I come to know that on 24/6/18, deceased died. But as the cause of death could not be ascertained, hence I instructed to conduct post-mortem examination and for further inquiry by police.
There are two inquests. One is of the body, one is of the head.
Head.
Okay. There is one DW. Doctor, of the
LGBR.
LGB. So he had opted for reducing DW in his 313. Let us see the 313.
Yes. Tip one be.
Do you want to reduce defense evidence? Yes. Question number 37 at
Yes,
page
sir.
58.
And why he had bolted that is also there. He had given
No,
explanation.
no,
at
those part will come later.
Let-
First, let us complete.
Doctor.
Okay. Because he has answered, responded to question number 37 in the affirmative that he wanted to give DW. Accordingly, and this was on 4/3/2000.
Yes.
And the DW1 was accordingly examined on
24/3/21. He is serving a senior resident doctor at mental hospital Tezpur. Today I appeared in court on being summoned from court. Today I have brought the medical register of the patient Rupajyoti Bora. He was admitted in the hospital against registration number so-and-so dated 26/5/2012. On 30/5/12, he was treated as indoor patient and discharged on 23/6/2012. After discharge as indoor patient, he continued treatment as outer patient at a regular interval till date. He was diagnosed with other mental disorder due to brain damage and dysfunction and to physical disease. I have also treated the same patient for few days. The said patient continued to be treated from jail also. Prior to first admitting the patient in our hospital, the patient met with a road traffic accident and sustained injury on his brain. Exhibit A is the register containing the medical document of patient Rupajyoti Bora, and Exhibit B1 to B60 are the medical treatment document of the patient Rupajyoti Bora. I have brought to court as well as photostat copy compared with the original. Cross. Apart from me, other doctors also treated Rupajyoti Bora. Exhibit B1 to B60 are document of treatment of patient Rupajyoti Bora, not by me alone, but by other doctors as well. Registration is done in the OPD counter of the hospital. We normally release the patient after improvement, but no cure certificate was issued.
See, this incident, not incident, the aspect of treatment is, as an indoor patient, is in May 2012.
30 from more than 23-24 days.
No, it is in 2012.
12.
The incident is of 2018. So as for 84, what is required is that the relevant time is the time of the occurrence. If you want to bring 84, which is under the general exceptions, it will not be an offense. So it has to be what is relevant, that he is legally insane at the time of occurrence. Now, is there any materials to show that this treatment, which was done in 2012, and the same, first, there has to be a categorical finding that he was not legally sane. There was legal insanity. And this persisted till the date on which the occurrence had taken place, that is 24/6/2018. Is there anything on record?
Because if he, the state patient continued to be treated from jail also.
No, jail is after his arrest.
Yes, Lordship.
Treatment after his arrest is something else.
In
Now-
between, Lordship.
No, at the before, just before the
That-
occurrence,
Lord-
maybe 18 June, the occurrence had taken place. Any documents or any materials that he was even treated in June, and simple treatment will not be enough.
2019.
18 also, Lordship, one history sheet. History sheet is there. Yes, record is there. Outdoor, indoor patient court record is also there. Follow
Yes.
up. This is follow up sheet is very much there. Lordship, it is there.
Date
Date, Lordship, 13.
131.
Yes, of 8 August, occurrences of June.
No, that is after
After
he
the
was elected.
occurrences. Relevant point of time, let me find it. Lordship, page 134.
Yes.
So 28/6. Jail record, a case of F06 diagnosis 2000 June, but no follow-up since May 2017.
No,
That
if you
means that he will-
come to the immediate past, you come to page 133.
130.
That is on 9/11/2016. He came alone, he was doing well. Okay?
10,
For
20,
then on 24 to
12,
12 came alone, better. Then 26/5/19. 17.
17.
Patient came alone.
Then 28/6/18. That is after the incident.
That is after the incident.
immediately after it.
28/6. That was while he was in custody.
Yes. 25/6 incident. So
From
20.
26/5/17, there is a long gap. Almost a year.
Yes, it's written in the report at page 130.
And see, and 26/8 from the jail.
Yes.
From the jail. So after this 26/5/17, there is no documents to show that he had required treatment.
Yes. Last was 26/5/17.
Yes.
Most of the are 12 and 13.
Let me see the case diary on the at the time of address if it was not.
And the observation by the doctor at page 134 on the date when he was sent from jail, 28/6/2018. A case of so-and-so, but no follow-up since May 2017.
Yes.
Or about 1 year. No suspicion, no
Fearfulness.
no showing violence or no suspicion, no fearfulness or no.
No hearing voices.
No hearing.
But after the incident, page 153, the psychologist report was there. 153. That is 19/7/18. To 154. Psychologist report. Test finding is no cognitive impairment in the patient at present. There is total
140?
153 from 153 after the incident, but his psychologist report is there.
Yes.
155. He scored well, so no psychopathology and no significant dysfunction. This is in 155. And impression is also there at the bottom part.
And at 156,
Yes.
even this is important.
Later, who is reference so and so? Attended our institute from 26/5/12 to 26/5/17. Later, he did not attend OPD for about a year. Then he was brought to our OPD again by police 5 months back. On 28/6/2018, it was made known to us that he was incarcerated in jail for alleged offense of murder. Since then, he has been receiving treatment from our institute. His last visit was on 28/11/2018. Based on his file record review till his last visit, it appears that his speech was relevant and he was well oriented to time, place, and person. His social judgment was found to be adequate and intelligence was average. He could comprehend the questions put forward to him and answers relevantly. He has been advised medications with periodic follow-up visits. This is the report of 3 doctors consisting of 4 dots. Impression normal.
Yes. Yes.
Then in his 313 lordship, he has stated that his, his given statement regarding his innocence is a person is their lordship in page in page 48, he has stated that in reply to PW1's, it is false, I did nothing, I was suffering from mental illness and is still under treatment. Now in next page, lordship, PW1, seeing many persons out of fear, I remain inside the room and dialing 100, calling police. So that is one. And next is, it is totally false, I only opened the door, but as soon as I opened the door, public assaulted me. I never told that I killed my mother. So opening the door is there, lordship, but there is contradiction regarding what he had actually stated. Some had stated that what he has stated they have not heard. Police entered there. And regarding page number 50, in reply to question number 6, he stated, I am innocent. On the previous evening, my mother went out from house saying me that she is coming, but since then, she did not return. On the night, I was in my room by closing the door. And according to him, no quarrel took place. And he always took up the meal, what is prepared by her mother. And he had not committed any offense. But he had only, after his mother had went outside in the previous night, and so he had closed the door inside, and he only opened the door, and then public assaulted. That is his 313 state.
He can put his signature in English.
He had read up to class 9. And in 2012, he had suffered something. He had a shop, and he even given articles in free, etc. there in 2000, but those are of 2012, immediately after his accident. That is why the Honorable Learned Court Fellow had
Okay. What are your submissions? Formulate your arguments.
Lordship, apart from that mental insanity part, that is, of course, there is some 1 year that is not there, but whether how much the degree of his insanity that is there, because the subsequent report also stated that he is.
What is the definition? Under the general exception 84. What is an insanity? Which will come under the general exception of chapter 4 of the IPC.
Act of a person of unsound mind.
Yes.
Nothing is an offense which is done by a person who at the time of doing it, by reason of unsoundness of mind, is incapable of knowing the nature of the act, or that he is doing what is either wrong or contrary to law.
The first requirement is at the time of doing it. And by reason of unsoundness of mind, he is incapable of knowing the nature of the act. He doesn't know what he is doing. So this has been explained that it is only the legal insanity which will come under the definition of 84 or in the ambit of 84. Now, what are the case laws on 84,
It could have many laws.
which will
Discuss
rely
also
upon?
there.
Because in the other day, we have come across judgment that
Opposed
this
judgment,
being a
Prakash.
this being a general exception, anyone can take the plea of legal insanity. But once you take the plea of insanity, the burden will be upon you. How do you prove it? Now, here you have done one endeavor by producing DW1. Now, will that be enough to bring it under the ambit of 84? The documents, those were proved by DW1.
Yes, original. It is proved.
Proved.
Yes.
The entire
Yes.
bunch was proved.
Yes. Proof in original.
So the aspect of treatment being undergone by the appellant in the LGB, that is proved.
That is
Now,
proved.
whether that aspect of treatment will come within the ambit of 84, that we need to see.
That previously he was seriously, his mental condition was seriously
Now,
dysfunctional.
there is a big gap of almost
Yes,
a year,
almost
almost a
yes.
year,
And one thing is
which
that
would have been the most crucial period. Because last he also says that there was a 1 year gap. He was an indoor patient in the year 2012, in May to June.
June.
Thereafter, he was an outdoor patient. But the last
2017 May to June 2018, there was a gap.
and the next visit was only after his
Arrest.
His
The
arrest.
arrest. And the subsequent report was there in after his arrest also, Lord, that he had recovered. And
But have you seen the number of injuries? It is not one injury. There are 4 injuries separately on the head, 1 injury on the neck, which is severed, and on the body also.
more so in 313 he had
And see, he was. Let us assume for the time being that he had done it, but he was insane. He knew that the body has to be dumped somewhere. He dumped the body somewhere else and the head somewhere else. What does it indicate? That
he is aware.
he knew that he had done something very grievous, heinous crime. He needs to somehow save himself.
Both aspects.
But apart
Putting
from
in a gunny bag, putting in the well, covering it with branch, then the head. And that is, of course, whether he is directly
Right.
involved.
Yes.
First,
yes,
first you need to,
Yes.
the prosecution needs to bring in
That-
that he was directly involved. If he
Leaving
is
a-
involved, then the aspect of 84 may come. First, his involvement, whether it is proved, that would have to examine.
Lordship, that is what my it's not the case of beyond reasonable doubt.
Why?
First of all, Lordship, the
So, what would ask you, you first hit on the point of his involvement at all. Then if you are able
Yes.
to convince us that his involvement itself doubtful, there is a reasonable doubt, then the aspect of 84 may not come in. Then if you are not successful in the first
Then-
endeavor, then you can argue on
Yes,
84.
Lord.
If you argue on 84, you will be almost foregoing the aspect of his innocence. Okay, we'll come back at 2. You formulate in that manner.
Lordship, can it be on Friday?
Let her come
Friday?
back today. We are, because we don't want to just, she'll hardly take half an hour. If you have a difficulty, you can, but in one go, you have a difficulty in the second half of what?
But
No, not Friday, tomorrow. Yes.
Lordship will kindly accommodate me because I am having a personal matter tomorrow.
No, we'll
After doing
accommodate you,
that,
but we don't want to give a gap. Once we give a
Lordship, then tomorrow.
tomorrow, okay? But to you complete your part today, okay? I don't think it'll take more than half an hour, okay? But just formulate in a manner which is,
And it has come up on record that he used to consume drugs and cannabis.
In
Habituated. Right?
no, his the post conduct, post the occurrence, that is also very relevant. And that part in the DW, question number 6, that the mother had left the place in the evening and did not return. There is no other except his explanation in 313. There is nothing. Nobody has said that they had seen her going out.
But one thing that
And
PW
rather, Potongia, who stays at a distance of, is a neighbor.
neighbor.
He heard the quarrel. He said that what is happening? If you want, you can come to my place.
But those were not stated before IO, not I. So there are some. I
Contradictions are there.
yes, the contradiction, and it is surrounded by wall 5 feet, 10 feet. How could he see whole incident?
No, he has not seen. He has heard.
He heard.
No, that
word.
morning part that he had
No, every day he used to see.
no,
He
that
was
he
heard.
had thrown something in the well that he has seen. Then he had not stated that, but after that,
What kind of wall?
5 feet and 10 feet
What wall?
brick
Or-
wall.
Brick wall.
Yes, in the sketch map also it is there. Only one side is open in the eastern and he is in the southern side. Those many things are there. And that he had also stated, everyone has stated that there is wall. It says it's not that there is no wall. It's surrounded by wall.
Okay, okay.
Yeah.
Formulate your submission. First is the mental insanity part.
Mental insanity part is there, Lordship, but that only came when he is found guilty, Lordship. But my argument is that the case is not beyond reasonable doubt. There are many such instances in this case which proves that there may be involvement of the third person in this case, except the accused, Lordship. Because the whole case is based on some circumstantial evidence. The circumstantial evidence, although the prosecution tried to project a scene, but that cannot be because there was no, except the PW3, but there is also contradiction regarding the previous night incident. That is the only chain of this case, Lordship. That some quarrel has been taken place, but there is contradiction. PW3 also have not stated before IO, and that is proved by the IO, nor in the Ezahar, although it's not required, but then also, Lordship, if we have to go by the contradiction, then, Lordship, those things were not stated, which were at least because those were the firstly he went there to tell Jiban Bora that this happened, but had there been actually those statements were there by the PW3, it should have been at least some reflection in the Ezahar. Or even if not there also, then also, Lordship, before that, because Ezahar is not in a hassas manner. It was in the very evening time. And till then, it's not that immediately they have lost the Ezahar. So some time was there. So they could have recorded those statements, placed those facts in the Ezahar also.
Ezahar may not be of such details that from where he had got the information. It was lodged by PW1, Jiban Gora. Jiban Gora got the initial information from PW3, Honokanta Potongia. Now, not mentioning Honokanta Potongia in Ezahar may not be fatal, but so far your argument that the PW3's version is contradicted by
IO.
the
IO.
And that he had not stated relevant facts before the IO, that
IO.
may be relevant
Yeah.
because Ezahar is something, not mentioning somebody else. But when that somebody makes a statement before the police, he is expected to say everything.
That vital part is not, because that is the only chain if we have to go by the circumstantial evidence. Because one of the witnesses have also stated that there is cordial relationship because there is only the mother and the son. He may be a he maybe is used to those narcotics also, then also it cannot be said that that is sufficient to even kill his own mother. He also knows that they are the only two persons their father had already
Which,
left.
who said?
The one witness said that there are cordial relations
Who said?
between. Lordship, I'll go to it, Lordship. Secondly, Lordship, though it is surrounded by many neighbors, even though mentioned some of the names, but instead of intimating to the neighbors, or had there been any such situation, at least they could have some information regarding incident, but he went absolutely to the relative of the deceased. It's not a big. That is also strange because there was no visiting term with those persons for last 7 years. Whom he went to intimate about the incident, with them they had no. For PW 1, 2, 3, 4, 1, 2.
But they say that while coming back this Patongia along with Jibon Bora, there were already some people gathered in the house of the, so neighbors were aware.
But these two main immediate neighbor, Kushal Sekar and Manoj Oza,
Yes.
according to the
they have
IO,
not- they have
they
not been
they have not examined, and even IO stated that their version, their evidence statements were not recorded because according to them they were not aware of the incident.
Yes.
That is in IO's evidence was their lordship.
Mm.
So this 1, 2, 3, and 1, 2, 4, and 5, whom he had went to intimate, and except 3, they are the main witnesses, lordship. They have no visiting term with them. Even in their only they were aware that some incident was taken place. After that, they have no visiting term. So that is also a little bit strange. Instead of intimating the Gaupura or else another person, he immediately went to intimate those persons whom they had no visiting term. Thirdly, lordship, in the paper book, I have found only one seizure list that is regarding the kukri, but regarding the dead body and head, etc., there was at least I have not
No,
found
the
it.
corpus should not be seized.
Neither the
Inquest was done.
inquest was done, but
Inquest is sent to postmortem. Those will not be exhibits.
not even lordship, those
It will not be
cloths,
seized.
wearing apparels, etc., were also not examined to see whether there were blood stain or not. Kukri, although Kukri was also there, lordship, according to PW1, there was blood, PW1, lordship, Kukri, page number 10, lordship, today I have not seen blood stain in material exhibit 1. This type of kukri are commonly found in everybody's house in village. I have not noticed any specific mark on the material exhibit 1 regarding ownership of the kukri. So that is not vital, but the kukri was also not sent for FSL. According to PW1, on the date of before the court, there was no blood stain. Whether it was immediately in the kukri there was blood stain or not, those not. Even the wearing apparel was also not sent for FSL. nor 164 statement of the accused was recorded, Lordship. 164 of only PW3 was recorded. Then, Lordship, that he had also given in his 313 statement that there was a huge gathering, and all the other witnesses also stated that some say 45, 50, some said 100 and 150. So all the local people gathered there, and he said that because of the fear of those people, he entered inside the room. He had not stated anything, nor he had committed any offense. And that is proved because the IO has stated that he was seriously injured and he has to referred to the hospital, and doctor had opined that because of this attack by the people, he has sustained injuries, Lordship. So if we go by the confession part also, Lordship, it is before police and it is not a voluntary. And he had also stated that his mother had went outside. And because if we go by the evidence of PW3, that there was some quarrel, in that case, although she had not gone to his home, she may have been went outside also. And the dead body was found outside the house, not inside the house, near in between the campus, but there was no, and in the entrance front side, there was no boundary wall. If Lordship sees the case map and even PW1, IO and PW3, it is surrounded by
Page.
case map,
108, 108.
page 140, 108.
108.
So here A is the house of Honokanto Potongia. A indicates the house of Honokanto Potongia. There is boundary wall, Lordship. And only in the front side that is visible from D, that is house of Manoj Oja, in between there is a road. That side is only open. B, A and C from the house of
Where is the deposition regarding the boundary wall?
Lordship. That is by PW1 at page cross-examination, Lordship.
Page.
Page 10. This is by PW10. Sorry, PW1. Last para. Near the house of the deceased, there are many houses, including Kusal Shekhar Manoj Oza. There is boundary wall in the house of the deceased, except the front entrance side. In front of the front entrance, there is a village path, namely so-and-so, and villagers used by Said Road frequently. So this is by
Boundary wall. What kind of wall? You said brick wall. Where did you get brick wall?
This is 5 feet and 10 feet. That
Where?
is given by IO,
Show us that.
Lordship.
What was the nature of the house?
Assam type house. PW3 had also stated about the wall, Lordship. PW3. Lordship, page 20. This is evidence of PW3. The Khanakanto Patankia. Paragraph 4. The house of the accused is bounded by wall on two sides. In my side, it is 5 feet height, and Decca's side it is 10 feet height. My house is in the southern side of the house of the accused, and Decca's house is the northern side of the house of the accused. On the eastern side, there is a village road, namely Howder Sukuri Pot. The entrance door of the house of the accused is on the eastern side. The house of the accused is comprised of 3 rooms with brick wall. And it is a Assam type house. On the day of incident, I, along with my wife and son, were at home. So this is 5 feet and 10 feet, Lordship.
Wall, what kind of wall?
Because this
It is a village.
sketch map, it shows that it's only a wall,
There is no description. It's a village,
Lordship.
Assam type house.
The brick wall pertains to the house,
House.
not the wall.
In that case also, Lordship, if Lordship sees the sketch map, the deeds, etc. are in the backside of the house. Backside of the house, and he is in one side of the house. The accused, that PW3's house is in one side.
See, a question was put to him at page 20, second last paragraph. It is not a fact that house of the accused is not visible from my house, and hence on the night neither I had seen the deceased nor on any conversation took place. Okay.
Lordship, I was page 40.
40.
40.
Yes.
As per the sketch map, there is boundary wall on the northern and southern side of the place of occurrence. In the sketch map, I did not mention the height of the boundary wall. there was no grill above the boundary wall. So grill is possibly, Lordship, only on a concrete wall, Lordship. So grill means it could be seen. If there was no grills, that means, Lordship, it's a closed one. Maybe a bamboo or maybe something, but it grill means, Lordship, it could be seen. But if no grill, that means it is not visible. Again, another point is that, Lordship, there is a land, and regarding that, he also wanted to buy that plot of land, but they had given taken 50,000 as a consideration amount of that.
From some broker, not him. He's a service holder.
He is a service holder, but he is an immediate neighbor. He also wanted to.
No, but that evidence has come. It was given to some broker, not to him, not to.
Not to him, but he may have the intention to, because he is the adjacent neighbor, Lordship.
That will be too far-fetched.
In your Lordship, if we have to produce that chain, we have to complete the chain. The chain starts from his suspicion that the accused had thrown something in the wall, Lordship. From that, but whether that is not visible from his house, that chain is not there.
How do you overcome the 106 spatial knowledge? A dead body without a head is found in your compound, that too of your mother, and it is found in a well, covered with garbage in a gunny bag. Head found in the same compound near the toilet, latrine, in a pit that was also covered. There is evidence that you had led the people to those two areas.
Right.
How do you explain? Let us, for the time being, forget about 27, leading to.
Because, Lordship, that he had shown it before the police. And before police, almost all the village peoples are there. So to bring section 27, that it has to be firstly from him.
Yes.
Already those people are there. So there may be from them he could have that knowledge.
Is there anything on record to suggest that the discovery of these two, the headless body as well as the head, was done by somebody even before the aspect of showing by the accused had come?
Except 313, there is nothing like that. And but bloodstain was also not there. That is according to the IO that he had washed it. Those things are a little that it cannot be said to be beyond reasonable doubt, because within that period, killing, throwing the body in two parts, but no bloodstain, not at all a bloodstain. If it has been washed away also, then also, Lordship, at least some bloodstain. So
No, bloodstains were found in the entrance.
Only one PW1 stated that
Yes.
in the door, outside door.
Entrance.
Entrance, that is by only PW1. But IO, etc. stated that he had washed it. And PW1 entered after at the place of occurrence after the IO. But IO have not seen any blood stain. PW1 had only stated one line. That blood stain was there. Not inside, but in that door. Place 9. Cross-examination by defense. That third line from the last on the second paragraph. I noticed blood stain mark near the door, but not inside the house. I could not remember whether the police had seen any blood stain cloth from the house of the accused, but IO has stated that no blood stain. And according to the IO, that it was washed away by the accused as stated by the person. Which gives the is the question that whether that it was the disease was killed outside and then it has been thrown inside the house because of the reason that to implicate it son lordship.
It was also raining heavily.
But then PW1, that PW1 could have not seen that because IO and other people had come before him.
No, in the night. In the night.
But
So
that
blood stains outside may not be a possibility. It is on
that is
record.
said according to them he had washed it away.
No, outside. We're just saying, there is on record, it is on record that it was raining heavily in the night. Yes.
These are the main lordship. If lordship after the public prosecutor replies, if necessary, I will reply to her submission lordship tomorrow. two Caesar witness lordship. One is Chitraranjan Bora and other is the PW1. Chitraranjan Bora had stated, I have not seen from where police recovered the cheese cookery. So he is in his cross, he has stated regarding that seizure of the, and according to PW1, it is available everywhere. And according to PW2, it is a Mesta. He had used a dagger or mid-down. According to PW2, weapon of offense is a dagger or a mid-down, and others stated that it is a cookie.
It is a mid-down. There's not much difference between a mid-down and a cookery. Dagger description. But the nature of the injury vis-a-vis the medical evidence is corroborative of the fact that weapon of that nature is only used. There has to be a sharp weapon by which the head can be severed from the body. Okay. We'll have it tomorrow
Lord.
then. But what about the 164 statements?
164 only
See,
Ghana
contradiction, you have all the right to bring in the contradiction. So once you try to establish the contradiction vis-a-vis the statement made before the police under 161, it is also our duty to see the variation, if any, between 164 and the deposition. 164 is also made almost contemporaneously, maybe 1 or 2 weeks.
Sorry.
So we find, see, police statement,
164
police statement, it's a kind of a double-edged sword. Something may be written which you are not required to sign. You do not know what is recorded. So if there is 164, which are there in this case, two 164, we have examined that 164 is almost matching with the depositions. Yes, contradiction, you have all the rights to point out to the court that this is the contradiction. You did not state before the police. But we have to be very careful. Okay. Heard Miss B. Sharma, learned Amicus, for the appellant who has concluded her arguments. On the prayer of Ms. B. Bhuya, learned APP, the matter is adjourned till tomorrow to enable her to make her arguments. List tomorrow, date. As part heard. It can have it too. Kalima useful.
Until 14 and 15.
Yes.
Lordship will pick some other day if possible. I prepare because this is a hefty petition. I prepare some paper book. Subject to what my friend said. Take document like segregate to. I can pass about these documents also. You know, this is a very hefty petition.
What do you say, Mr. Kathari?
Healthcare call for.
No, healthcare call for that's all right.
Some documents they have annexed with the first step. In every ground, they have annexed some document.
Now, what do you say on his prayer? He wants some other day.
My lord, it is a very, since 2014, this petition was originally pending as a repeat. Subsequently, RF
then it is converted to hill appeal right. And fruits of the decree, they fail to enjoy by the village people, tribal people. Their land without acquisition, my lord, they have constructed their
No, on
city
merits,
land.
and on merits, we are not even entering. If you are agreeable to the proposition of
we are-
Mr. Senior Counsel, then we'll have it another day. Otherwise, we'll have to, yes, what do you say?
Highly 2005, my lord.
If my learned friend does not agree, then I have to proceed.
No, that is on 14, my lord, 14 May. And
14
other
May.
day I will be absent. I will not be present.
Okay,
in
but
the-
14 day, then you make a mention early in the morning, we'll give preference to your case.
Yeah.
Because this appears to be a hefty,
Happy petition. That is why I have segregated. In the
And-
meantime, your lordship may can.
and
go to
Mr.
the-
Dasgupta, if you want to exchange anything more, you can give the copy in advance so that Mr.
No, I have
Kasur-
given already given. I have
No,
given.
He
these
can also come
documents,
prepared.
They have annexed. These documents.
No, these are
I
the
think-
documents which I have segregated from the petition.
It is
Land,
not new.
Not
These are
new.
already on record. We have-
Already on record.
the con-
Not only, it is in the petition itself.
Okay, for the convenience of the hearing.
For the convenience of the hearing. I will prepare. I have prepared a brief note, but this note was prepared for civil revision petition. I have to convert it as a
You
civil.
convert in the appeal, what is
Appeal
the
bill.
matter? What are you challenging?
No, basically, case before your lordship is that NFLA undertook a project to convert their meter gauge line to broad gauge line from Badarpur to Station Division.
Okay,
For that purpose, some land were acquired. And the person concerned whose land was acquired, they were paid with the compensation.
okay.
Thereafter, my lord, some persons institute a civil suit. They say, according to them, that they are affected person, not land acquired person, they are affected person. And initially, this civil suit, one order was passed by learned Minister A.K. Borua, Anil Kumar Borua.
Deputy
Then-
Deputy Commissioner.
Deputy Commissioner. He was then Deputy Commissioner on 10th of January 2006. Thereafter, my lord, he himself has revoked this order within 2 days.
What was the order?
Order was just some compensation amounting to rupees 10 crores or something has to be paid.
That it was revoked.
That was revoked. And this affected person felt aggrieved by that order. They approached before the National Commission, Tribal National Commission. Tribal National Commission sought for a report from the local report. And local report, on the basis of the local report, the Tribal National Commission of the office was of the opinion that there is no case.
Okay,
Then they have prepared a PIL.
okay.
They have prepared a PIL. Then in this PIL, my lord, this court has an occasion to make some observation. Already, if they have acquired some prescriptive right, their case may be considered. Then, my lord, they again passed an order, District Council Court. That order was assailed by the railway authority here. The railway authority set aside that order, and they went to the writ appeal. There is a the writ appeal, and pursuant to this writ appeal orders, my lord, this civil suit decree was against passed, my lord. That is the chronological finding, my lord. I will give some note, well, so otherwise, if you have to go through the entire record, it will consume. Basically, case is in very narrow compass. Whether they have their any prescriptive right or not. Our case before the court was that railway authority has the land 50 years by the both sides of the land, railway line.
Okay.
And these people were encroachers according to us. And according to the learned court below also, they were encroachers.
They are encroachers.
They are encroachers. That finding is there. I given this thing. And a genuine person we have, for the genuine person we have paid the compensation. And my lord, that apart, my lord, we have deposited in this court 50% of the amount. another day, if your worship fix, then I can give a list of dates. All the documents are there, relevant documents are there. Therefore, lower court, state court also come, is also there. For the sake of your lordship, convenience of your lordship, I have prepared all this. All right, no problem.
Just a minute, please have your seat. Please have your seat.
Oh, God.
According to you, the persons whose lands have been acquired, they have been already paid.
Yes, yes.
Now, how they claim to be affected?
Because basically what I have understood, my lord,
Yes.
they had land, railway land, it is since the days of Assam Bengal Railway,
Yes, yes,
about 50 to 60 years back.
yes.
That.
More than that.
More than it, maybe more than that.
Yes.
Now this land was lying vacant. Some people have constructed their house and they have grown paddy, etc., etc. And when these works executed,
Yes.
the art filling, all these things were taken place. Probably they were affected in that way. Because there is a specific finding in this regard that they are encroachers. After that finding, my lord, they formulated some issues. Issues were framed, issues were answered, and by holding that they are encroachers, then the land compensation has to be determined. While determining the compensation, the next next deputy commissioner rewrite an entire judgment without going to the earlier order and without discussing any evidence whatsoever. He has came to the conclusion to pay and directing us to pay 34 crores and all.
Why was the Supreme Court, Honorable Supreme Court approached?
Because there was a delay
Okay,
in filing it.
okay.
Then, Lord, this delay was condoned.
Condoned, okay,
And then they approached before this Supreme Court.
okay.
And Supreme Court dismissed this petition and with an observation that whatever you want to say, you say. In fact, Lord, I have some doubt whether this division bench can take up this matter or not. Because yesterday I have gone through a judgment, I could not collect this judgment. There is a full bench judgment. ALR 1969, page 92.
Hill appeal. Regarding Hill appeal.
Full court judgment of this court, Lord, but I could not collect it.
What was it?
ALR
No, regarding what?
about the whether it will about whether it is a first appeal, etc. I have not gone through that judgment. Without going through this judgment, I should not say anything. I have to refer ALR 1969 ALR page 92. No. Full court judgment.
Name?
Name to person was this. Huh? What? Was this? I shall try my best to collect it from the High Court
No, see,
library.
if it is in ALR, you'll be able to get it.
Huh?
If it is in ALR, definitely you'll be able to lay your hands on it.
No, it is also maybe in the AIR also. After ALR 1969.
No, why?
Anyway, I shall collect it. It may not be very important so far this case is concerned.
I'm also looking into the aspect whether this court can take up the matter.
Yes. That
No,
was
no,
my
not
anxiety
because-
blood.
Not because of that. Whether this.
Full bench has delivered a
Not
judgment.
because of full bench. Whether one of us had dealt with the matter, that was, name appears to be familiar, that is why. Mr. Kathadurika, did this court appear as a counsel?
From the registry, came to my came to my knowledge, my lord. That this is the first Hill appeal.
Oh, your lordship was standing on.
So any counsel, and
Oh.
this matter are old matters.
Oh, probably, I don't know that.
Name appears to be slightly familiar, therefore I am.
But I didn't notice it yet.
And the period appears to be of the same period, so therefore I'm just trying to.
Sorry, Lord, I could not detect it.
No, if there is no problem, then there is absolutely
No, I
difficulty.
have.
But later on, it should not be.
Yes.
I'm just trying to.
So the
Mr.
better-
Kathadurika will be since you are the counsel
Yeah,
consistently.
probably he should be aware. You should be aware. আমার ম্যাজিস্ট্রেট আসেন নাকি
As
KL actually,
I
কিন্তু এটা রিট পিটিশনত
And I'll like to read it.
cause of action remains same that
Read it.
time.
Then,
When-
that is why I find it
Yes.
very.
No, I was not aware of this thing.
No, in
No, Mr.
2008,
Kathadirika, you should be, because if you point it out, and tomorrow if it comes to our
Your
knowledge, after
Lord-
hearing the
No,
matter.
actually, I was,
Your
I
lordship
did not,
has-
I did not check upon this
your
line.
lordship has filed a writ petition. And
Oh.
that writ petition disposed of by the Justice Biplov
Oh, yes, but I have not seen who was the lawyer.
That-
I have, though I have gone this through the judgment.
That doesn't also have, we have an act.
No,
That doesn't have been,
that
but I have
does-
just checked up.
That does, judgment does not contain the name.
Okay.
Justice, Honorable Justice Sharma's judgment. But name of the parties appear to be very, very familiar. Therefore,
Oh,
we're
Yes,
trying,
yes.
going through the
My-
record.
Probably
Yes.
my friend can,
What was it? How was it involved? How was this court involved? Which matter?
My lord, when PIL has been disposed of,
Yes.
and that time writ petition filed by your lordship that was pending before the court. And that time Justice Biplov Sharma has disposed of that writ petition in the light of what the division bench decision of what.
Oh, will
Yeah.
not be proper.
Yes,
Not be proper.
so some other bench issue it is required to be.
actually, I was not aware of.
Now, you have come to the proceeding recent. But in
Okay.
2007, I have filed the PIL before the High. And PIL in the PIL, my lord, entire matter was reopened.
Okay, okay.
Entire matter was reopened, and it is and directed the trial court to take up the matter.
Yeah, it's good that it has come to light. I'll recuse. Okay. Heard Sri A.K. Dasgupta, learned senior counsel assisted by Sri Goswami, as well as Sri D.C.K. Hazarika, learned counsel for the respondents. Full stop. However, on going through the records, this court, going through records and as informed by the learned counsel, it has, this court has come to learn that in a connected litigation, one of us, brackets, for instance, was a counsel. Therefore, it will not be appropriate for this bench to take up these matters. Accordingly, it is before any other bench without one of us, brackets, for instance. Mr. Dasgupta, you can take this back. You can present it before the bench, which will take up
All
the
right.
matter.
Yeah, he could have informed, he could have told me. I,
No idea about
uh,
Because on the last occasion it had come when the matter was adjourned, then also it was coming in our mind. Both Mr. Kathadurika was familiar that as if.
I had no
Some
occasion to think in that way.
How do I make it matter? Okay.
খালি বুঝিব পাৰিলে
হা?
খালি প্ৰণৱ লাগে
মই কোৱা নাই কিয়